May I please, my lord?
Yes.
My lord, I have instructions to appear in item number 12 for respondent number 2.
You haven't filed wakalatnama?
Not yet, my lord.
Item number 12.
Item number 12 for respondent number 2.
So you need some time to...
Yes, to file my power and also to file the counter.
Okay. Mr. So-and-so.
I, Jamir.
I, Jamir, the learned counsel appearing for the... Then Mr. Jamir submits that he has got instructions to appear in the matter for respondent number 2. Therefore, he prays for some time to file the wakalatnama as well as counter affidavit in the instant matter. Prayer is allowed. Let the matter be listed after 2 weeks.
3 weeks, madam.
After 3 weeks.
Obliged.
You are appearing for the petitioner?
Yes, Your Lordship, I'm for a bit.
Mr. So-and-so appears for the petitioner. Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 14.
Item number 14.
Yes, Your Lordship.
Yes.
Lordship, my senior has some personal difficulty today, so kindly...
Your senior is Mr. P.J. Saikia?
Yes, Your Lordship.
MS So-and-so, learned counsel appearing for the learned senior counsel P.J. Saikia, who is leading the case, submits that Mr. P.J. Saikia is unable to appear in the matter today. Therefore, she prays for some time.
Kindly list this matter on 27/11.
She prays for some time and she prays that the matter may be listed on
27 November.
27th of November.
Yes, Your Lordship.
Mr.
Lima
You are appearing for the respondent.
Respondent 2, Lordship.
So-and-so, learned counsel appears for respondent number 2, doesn't have any objection to the prayer so made. Let the matter be fixed on such and such date.
Lordship, there's the interim
The
continue.
interim order so passed earlier shall continue till the next date of listing.
Okay.
May I please, Your Lordship? I beg to mention items 17 and 18.
Item 17 and 18.
Yes.
Yes.
I would like to make a mention on behalf of the Principal Counsel Teji Hailo. He is an outstation lawyer, and the local counsel is also indisposed. So kindly fix the matter on the...
You are appearing for the applicant.
Yes, Your Lordship.
Mr. So-and-so, the learned counsel appearing on behalf of...
Date 11th of November.
On behalf of whom?
On behalf of TJ Hailo.
T.J. Hailo, the learned counsel appearing for the accused applicant. Accused applicant submits that Mr. Hailo is not available in the court today. Therefore, the matter may be. Therefore, praise for listing of the matter on
11th of November.
11th of November.
Your Lordship, there is an interim order.
You are Mr.
Lordship, I'm for state. I'm the PP.
So-and-so appears for the seat, and he doesn't have any objection to the prayer so made. Let the matter be fixed on 11th November. The interim order so passed earlier shall continue till the next date of listing.
Obliged.
May it please, Your Lordship. Lordship, I would like to mention from hearing item number 16.
Item number 16.
Lordship, I'm
Yes.
for the respondent 1 to 4.
1 to 4. You have
Lordship.
intimated the counsel for the other side.
Lordship. 3 weeks time may be given to you, Lordship.
Mr. So-and-so, the learned counsel appearing on behalf of respondent number
1 to 4.
1 to 4 submits with consent of the counsel appearing for the applicants that he needs some he should be given some accommodation and prays for the matter to be listed after
3 weeks, Lordship.
after 3 weeks. Let the matter be fixed after 3 weeks.
Obliged, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 9, Lordship.
Item number 9.
9, Lordship.
Yes.
Lordship, here we are yet to receive instruction with regard to the continuation of delay, Lordship. And then we will be filing our objection. However, till such time, Lordship, I am yet to receive instruction. Kindly grant me 2 weeks' time, Lordship.
Mr. So-and-so, the learned APP. You are APP, right?
PP.
A learned PP. Learned PP submits that he is yet to receive the instructions in the matter to file an objection to the
Condonation of delay.
Objection to the application for condonation of delay. He prays for 2 weeks' time.
Lordship.
2 weeks time, prayer is allowed, let the matter be fixed after 2 weeks. MS so-and-so appears on behalf of the
Appellant, Lordship.
appellant.
Much obliged.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 15, Lordship. If this matter can be passed over for the day, Lordship.
On the prayer of MS so-and-so, let the matter be passed over for the day.
No, sir.
For motion, item number 1.
Yes,
Please, Your
yes,
Lordship. My Lord, Your Lordship will just give two statute. One is the Criminal Procedure Code and one is BNSS.
yes.
This before,
Just give me the statute.
these two
BNSS.
statute is important, BNSS and CRPC also.
And CRPC. Yes,
My Lord will kindly see, this is the second time we are moving this matter.
correct.
But I like to show the judgment why we withdrew this case at page 43, my lord.
Yes,
I think there is the history of the case
Yes.
has been narrated. I think, my lord, it's important, your lordship, because it is not so long. It is up to paragraph 12. May I
Yes.
read this, my lord? Your lordship
Yes,
will
yes.
understand.
Yes, yes, yes.
This judgment
Yes.
is connected with rest of other cases
Yes.
because this is a predicate offence. My lord will kindly see paragraph 2. The petitioner files this application under Article 226 of the Constitution read with so and so for questioning of the proceeding in Kohima Cyber PS case number 3 of 2021 under section 120B so and so. Learned counsel for the petitioner submits that an FIR was lodged against HPZ token and others for duping thousands of people throughout India in crores of rupees on the pretext of doubling the investment by app HPZ coin. Based on the above FIR, a case was registered being Kohima Cyber Crime PS case number so and so under section 420, 120B of the Indian Penal Code, read with section 66 of so and so. He further submitted an allegation of the said FIR is alleged HPZ token and Messrs. Lillian Technocap Private Limited and stated that the petitioner nowhere connected with the said HPZ token or Messrs. Lillian Technocap Private Limited, and as such he is not named accused in the FIR. However, based on the above FIR, the investigation has been carried by the Director of Enforcement in connection with the enforcement case information report number so and so dated 12/4/2022 arising out of Kohima Cyber PS case number 3 of 2021. I'll just pause for a moment.
yes,
Basis of this FIR, the ECR has also registered a case.
Correct.
And accordingly, complaint has been filed, which is all pending before this honorable court. Now, the learned counsel for the petitioner submits that although the said FIR were lodged and registered by way of 18/10/2021, but so far no any notice has been issued to him by the IO of the case in connection with Kohima Cyber Crime PS case number so and so, which shows that there is no case against him. So and so learned PP for the state of Nagaland submits that if the petitioner is nowhere connected with the above Kohima Cyber PS case number so and so, if he is not involved in this case and is not named in the FIR, the petitioner then has no locus to file the present petition, seeks for questioning of the state proceeding concerning some other person. He is praised for dismissal of the petition. In support of his submission, learned PP cited decision of Honorable Supreme Court so and so. Now this judgment has been cited. R.K.D. Chaudhary, learned so and so for response number 2 entry submit based on the complaint against HPZ token and others disclosing the thousands of persons were duped by this entity on the pretext of investment for Bitcoin. The Kohima Cyber Crime PS case number so and so dated 8/10/2021 under section 420 120B of the Indian Penal Code read with Section 66D IT Act was registered. He further submitted the offence under Section 420 and 120B of the IPC fall under paragraph 1, part A of the schedule of the offence under the Prevention of Money Laundering Act. Therefore, the matter was examined by Director of Enforcement Dimapur, Sub-General Office, and since prima facie case of money laundering as defined under Section 3 of PMLA, punishable under Section 4 of PMLA was made out, a case was recorded by an enforcement case information report by dated 12/4/2022. An investigation was initiated under PMLA, where it was found that an entity by name Freebie Solution Private Limited has several transactions with another company, Messrs. Shark Enroll System Private Limited. Freebie Solution Private Limited is the entity enrolled by the petitioner Bhupesh Arora, where he and his father Gulshan Arora and the directors and between the period from May 22 to November 22. Petitioner Bhupesh Arora, using the API integration with Shark Enroll System Private Limited, has made payment of rupees 900 crores, which was the amount of unregistered online gaming and gambling, and therefore under facts and circumstances of the case, it is too early to come into a conclusion. Petitioner is not involved in the case only because he is not named accused in the FIR, and he is also too early to interfere with the investigation of the case, as the matter is still at the nascent stage of investigation. So just pausing for a moment, the counsel for the ED has argued before the court that we have seen that there is some transaction of 900 crores, but so far it relates to a mode of payment is unregistered online gaming and gambling. Therefore, some type of involvement is there. We counteract. I was not there in this case, my lord. The submission will be whatever the proceeds of crime, so far as the main predicate offence, it has to be some connection for registering case under ECIR, because that proceeds of the whatever act has been done under the predicate offence, criminal activity, that has to have a connection with the so far the ECIR registration of a case concerned. The proceeds of crime has to go from the act of criminal activity which has been done. So what argument of the ED was that no, he is involved some gaming and gambling. So some 900 crores has been transacted, but it has no relation with SPZ token.
So according to you, that's a different issue altogether.
Altogether.
And that there should have been a different complaint for that.
Yes, no connection.
If at all.
If at all. Now, my lord will kindly see 8. At this, the learned counsel petitioner, by relying upon the above referred decision of the Honorable Supreme Court in so and so, submitted observation made in the above case squarely covers the present case of the petitioner. He further submits that in the instant case also, it is not disputed that the petitioner is not a named accused in the FIR. And in view of the decision in the above referred Supreme Court case so and so, learned counsel petitioner prays that this petition may be disposed of in the line of the above referred case, with liberty to the petitioner to take recourse to appropriate remedy as and when the petitioner is named. My lord will kindly mark it, is named by the investigating agency in connection with Kohima cyber PS case number, which is now under investigation. My lord will kindly mark this 4 line. In referred case, with a liberty petitioner to take recourse to appropriate as and when the petitioner is named by the investigating agency in connection with Kohima cyber PS case, which is now under. That means there is no direct name of the present petitioner in the Kohima cyber PS case concern. Whenever his name appears, then the situation will be different. Now, paragraph 10 and 11 is most important, which, my lord, there will be an objection by my learned friend. It will come, and I have to give a reply to him. So, see kindly para 10. The CD is also called for and has been produced, and I have perused the same. The investigation conducted so far reveals that the petitioner is found involved in money transaction, which is ultimately linked with transaction in the present case. So some type they found, some transaction is there. Which transaction, how it is connected, nothing has been mentioned. However, since the petitioner, now my lord, this line is important, is not pressing for disposal of the case on merit, and his limited prayer at this stage is to dispose the matter with liberty to the petitioner to approach again as and when the petitioner is named by the investigating agency in connection with Kohima Cyber PS case now under investigation. I am of the opinion that this petition at the instance of the petitioner can be disposed of. So whenever, my lord, after investigation of the case, whenever the name appears, then only there be a liberty which is taken by petitioner, my lord, to approach this honorable court, if necessary at all. But at this stage, now kindly see at paragraph 11. Accordingly, in view of the above submission made by learned counsel for the petitioner and as agreed upon by the learned counsel for respondent, however, without going into merit of this case, the writ petition is dismissed with liberty to be granted to the petitioner as faithful. Now, I have approached this honorable court again. Now, 2-3 issues are there.
Have
which
you
is
been
very-
named now? Named now?
Now, this is important. This is very important, whether I have been named. Suppose I have not been named. Let us say that I have not been named. Whether I can approach the honorable court. Because once again, because this is what paragraph 10 and 11 says. I have to be named. Now, they say now before the court that I have not been named. Then your lordship will immediately ask me, see Mr. Das, your name is not been revealed. And paragraph 10 is very clear. Once your name comes, then only liberty, you have taken liberty, you will approach this honorable court. Your name is not there. But if you see that there is one statement which is made by them, that there is something it reveals that is involved in some money transaction. Which is money transaction? My lord, if the ED, their case is that ED comes to the court, in this case, maybe they may have not have some role, because what we catch hold of them was that there has to be connection with the predicate offense vis-a-vis the ECIR, which they have registered, which now culminated into filing of a complaint by the ED. But suppose tomorrow, my lord, now they doesn't find anything in predicate offense. Suppose, for an example, let us say, in criminal activity, with the proceeds of crime, they doesn't find anything, big zero. What happens to all these cases? Now, if there is no proceeds of crime arising out of that criminal activity, then now where they are proceeding with that complaint, that they cannot. Now, what it says, there has to be a connection with that case, the predicate offense which they have filed. Now, today why I have approached? This is a question, big question before the court. Even if in paragraph 10 there is an observation which has been made, whenever your name appears. Now, my lord, this is 2 statute which I have asked your lordship to keep besides. Why? In the CRPC, this case was registered when it was under the CRPC. Now your lordship knows that 1st of July 2024 the BNS has come into effect. Now what is the effect of it? Now I have not come across, my learned friend has helped me and said there is no provision in the CRPC then when the investigation will be completed. There is no time limit has been given. No time limit. It can be 10 years, it can be 20 years, it can be 30 years. No time limit so far as the investigation part is concerned.
Under CRPC.
Under CRPC. Now the legislature felt that no, there has to be a time limit because you have to put them on time limit, the investigating agency. So these are procedural, my lord, procedural law. Now, so time limit now it has come with the virtue of that BNSS. 1st of July 2024. Now, your lordship will please note it. The case is registered in 2021. So now, the argument which may come from the other side, that's why I said, I am prepared for that. I'll give an answer before that. The investigation which they have carried out is under the old Act, 2021. Now, BNSS came 1st of July 2024. Whether it can be given a retrospective effect of or the investigation has to be carried out under the provision of the BNSS, which they have to complete within a period of 90 days. So this provision now, today I have approached this Honorable Court. Why? 1, 2021 the case has been registered. There is no time limit which has been given so far as the old CRPC is concerned. Number 2. Number 3, 1st of July 2024, the BNSS has come into effect. Whether number 4, whether I get the benefit of BNSS, where the investigation has to be completed within a period of 90 days. This is the 4 broad line. Question I am putting myself, because this is the hurdle which I have to cross paragraph 10 and 11. Your Lordship rightly put, whether your name appears in the, ultimately whether your name has to appear. I said it is not. I know it, that's why I drafted this petition, my learned friend, knowing fully an alternative prayer has been given here. Alternative prayer we have made. So it is not that we cannot approach again before the court. Alternative prayer, I'll show it. First, let me make clear what is the provision under the CRPC when the case was registered. 2021. My Lord, I'll put in a very simple way. There was an app where a case had HPZ token app. Now in that app, they lured a lot of people in Kohima. They said you deposit a certain amount of money, you will get double the amount.
You know, one thing, first of all, I mean, we'll hear you,
Yes.
but first thing I'll have to, I think I will have to ask the counsel for the other side. Do you have any objection to this, filing of this petition? Is there any objection for this? Why? What is the objection?
Because for the first...
In very short, because I have not completed hearing you.
Yes.
No, you are raising some objection in filing of this petition?
Yes,
Why?
because the paragraph 10 clearly says that unless the petitioner is named in the FR, he is not entitled to file again.
But if during the investigation, see, from the records, what I could lay my hands, I could find out that there was some mention about his name, correct? Linking him to this, linking him to the PMLA case.
Yes.
Correct. Now his name has come. His name has already surfaced. And the investigation actually started from this, but it culminated in filing a complaint under PMLA also. Now his name has come. Now whether he has any right to come before this court?
No, Lordship, because it clearly says that his name is not at all reflected in the FIR. Now they have come to...
See, we'll have to see the scope of the crime, like alleged, scope of the crime alleged. Now the scope of the crime is alleged is a cyber crime.
Lordship.
In cyber crime, usually what happens, like the person who is filing the complaint, he may not be knowing it, who is behind all these offenses. So they file an FIR or complaint without giving any name. Names may come later on.
Yes.
Names may come later on.
Yes.
So when the name comes,
Yes.
name surfaces, then whether he can come or not.
But not as an accused. Not as an accused. Now, even leave alone the filing of the FIR. Charge sheet has been submitted. Not even the charge sheet is arraigned as an accused. Then, where is his role? He's totally a stranger. Even they know. The local council, they themselves have confirmed it and told me that it's not filed. Not in the charge sheet.
So your submission is the charge sheet has also been filed?
Yes.
And he is not named in the charge sheet?
No.
So where is his case of like filing this?
Yes, yes, no
this
locus
is
standi
case.
at all. In view of the judgment passed in the previous writ petition, in the first place, he doesn't have any locus standi approach. Even if on merit, he doesn't have any locus standi because he's not named in the FIR in the first place, and the ratio laid down by the Hukum Chand case by the Honorable Court. Then subsequently, even the charge sheet, his name is not named. So, as far as this case is concerned, no her petitioner has a locus standi.
Okay, we'll hear you. Let him complete first.
Well, I am thankful for my learned friend that it is now, it's open, that I have not named in the charge sheet. So it becomes very easier for other cases. Well, I'll tell your Lordship, if I am
The
not...
charge sheet filed in this case.
Yes, if I am not named as an accused in the charge sheet in this case, all the ED cases falls down. That's the case. That is why I came to the court. If I am not named in the accused in the charge sheet, my lord, then it's become very easier insofar as other ED cases is concerned. All cases falls down. If I would have been named as an accused in the charge sheet, yes, of course, then ED cases would have been continued. But the criminal activity,
But in the PMLA, you are the main accused.
this is the case. This is what I am saying, my lord. Now it apparent from these the public prosecutor from Kohima Cyber PAS case, my name is not there as an accused in the charge. What happens to all those cases, ED cases?
So basically, what relief you are asking in this?
Kindly see the prayer. See the prayer.
And charge sheet has been filed against whom? How many people?
Four of them, Lordship.
4 of them.
Yes.
Okay.
Friend, copy.
Yes, your local council also know.
Good, huh?
He knows. I have only this one now.
One extra copy after court matter is over.
Okay, we will manage later.
I asked my learned friend, my lord, if the copy, the charge sheet can be given to us.
I think the local council also knows very much. So of course
has
I'll
not been,
provide on my ends, but not for the sake of prolonging the matter. I think there should not be a ground now.
No, that's not.
No, Lisa, I am saying that I should get the copy. There is no question of taking any adjournment in this matter. I have prepared, I will argue this matter. First,
No, Mr. Das, in this matter,
yes,
what we can do best is that we can issue notice.
that's what I am saying.
And another thing is that we'll have to, call for these records, whatever
Yes.
they have filed. But
It's been dragging on since June.
which one?
This is already surfaced on appeared before this court on 13 June.
This matter?
Yes, and I have objection even for issuing notice in this case.
Why?
When there's no ground, Lordship, is
No.
where is the loophole?
The only thing is that you have submitted, is that charge sheet has been filed.
not only that, Lordship. In the first place, this is like
The
this.
thing is that the court has to produce the records, right? Court has to produce the records.
Lordship, another date may be, Lordship.
No,
This court has been, for more than many occasions, this court has been producing the matters.
No, I don't know about the other courts, but like this court.
Yes,
This court has to see the records.
Lordship, charge sheet is also here, Lordship. Otherwise, even it is very simple and very clear. Paragraph 10 clearly says that only when the petitioner's name is named in the FR, he can approach again, which is not the case. In the second place, in view of the paragraph, page 46, paragraph 6, Hakum Chan Guard case.
So you can do one thing, you can bring on record all those things by filing an affidavit to this.
Lordship, what is there to?
No, without going through the records that you have only on the basis of your submission, we'll have to peruse the records. We'll have to see whether what is there in the charge sheet, whether other people have been arrested or not, whether other people have named him or not.
Even if that is the case, what is to do with the petitioner, Lordship?
Sorry?
What is to do with the petitioner now? Because when he's even an accused, named as an accused in the FIR, isn't named as an accused in the charge sheet.
No, that will be good for him. In fact, that will be good for him for the other cases.
That is why. What is the?
That will be good for
what
him
is
for
the
the other cases.
For the others to take trouble, Lordship, even for this honorable court, wasting honorable court time.
Yes, anything else, Mr.
See paragraph E, my lord. Paragraph E of the prayer.
We'll hear him.
Page
Paragraph?
14. Page 14.
Page 14.
Yes. Paragraph A. Prayer A, my lord. Prayer A at page 14, my lord.
Prayer A,
Yes.
yes.
See paragraph E, my lord. Now see paragraph 7 of the writ petition, my lord, of the case. 7. Pleadings, my lord.
Paragraph 7, yes.
7.
Yes,
That a petitioner further submitted prolonged investigation and collateral PMLA proceeding have inflicted harassment, mental agony, reputational damage, and financially uncertain, necessitating urgent judicial intervention to prevent irreparable harm and uphold the rule of law. Paragraph 6. Why interference is paragraph 6 kindly be seen, my lord. Paragraph 6. Paragraph 6. That a petitioner states, Lordship got it, and consequent to the FIR, he has been unjustly implicated in collateral proceeding initiated by so and so under prevention of money laundering case number so and so, dated 12/4/2022, which is wholly premised on the FIR as the predicate offence. Moreover, furthermore, the ED has filed a complaint being complaint number so and so registered as ML case number 1 of 2024 under section 3. Read with section 70 of PMLA Act, punishable under section 4, currently pending in the stage of consideration of charge before the learned special court, Dimapur. The petitioner challenged the said complaint on the ground, there being so and so. Petitioner crave leave of this honorable court, relied upon documents submitted along with the complaint, submitted by Director of Enforcement registered so and so, now pending in the stage of consideration of charge before the learned special court. Now, if your lordship kindly.
you see, like now, only thing is that, whatever, the submissions that has been made in the earlier petition,
Yes.
as well as the recording by this court, as far as submission is concerned. So there was a clear cut, this thing,
Yes.
clearly it has been stated that the liberty has been given only in the case of the petitioner is named.
Yes.
If the petitioner is at all named in the
Yes.
in the FIR, correct, or in the complaint,
Yes.
on a later stage, of course.
Yeah.
Now,
If the,
if there is no such complaint has been filed later on, or any allegation or separate allegation has been made against the petitioner, where is the new cause of action? And on the top of it, he submits that there is a charge sheet filed, and in the charge sheet you have not been named.
Very well.
So in that circumstances, whether this petition, whether any cause will
very well.
lie.
Very good. Now it makes more easier. If you see the PMLA Act, see the PMLA Act. This case is wholly becoming prejudice to the case, the PMLA Act.
No, only thing is that, like, see, on the basis of this FIR, there was an investigation.
Yes.
And during the investigation, some link has been found that this money, whatever the money, that has been collected from this region and on the basis of the complaint, that is linked to the main accused, and who is involved in other offenses or alleged offenses also. So now that's how the PMLA case has been, complaint has been filed. Now, the basis of this case, of course, the investigation started with this. Now, in the basis only, there is nothing has been found against him, it seems, because the charge sheet has been filed.
Yes.
And the charge sheet, no charge has been filed against him. The only thing remains is that like PMLA complaint. But the PMLA complaint is an offshoot of this, this FIR.
Yes.
So now, since you are linked to the PMLA and like PMLA, there is a complaint filed against you, specific complaint has been filed against you, you have been made the main accused. Whether this case, you will have any kind of cause of action in the...
Now, Your Lordship, suppose they files an affidavit and they come up with an affidavit saying that I have not been linked in this, neither I have not been named in the charge sheet also. They have to file 2 lines an affidavit form. Like tomorrow they can come and they can file before the court. There nothing has been found. In the charge sheet also, my name also has not been disclosed. Then what ultimately logical conclusion will be that your name has not been linked the charge sheet also. So we know how to deal with this particular case. We will see it then. They have to come up with that prayer because ultimately it has to lead. So a small affidavit, they can come up tomorrow itself and say that this is what our affidavit says, that he has not named in the charge sheet also. So petition should be dismissed. Absolutely no problem. Let it be like this.
My lord, as far as ED is concerned, may I submit, my lord, as far as ED is concerned, whether he is named in the FIR, not named in the charge is irrelevant in view of the pronouncement of the Supreme Court in Pavana Dipu's case. So whether he is an accused or whether not an accused is immaterial.
But he is not named in this particular, I think ED is not a party.
No, we are not concerned with that aspect.
Because my learned friend said that it becomes easier for me in the ED cases. It's
Yeah.
not as simple as my learned friend is trying to depict.
His submission is to the effect that if the learned PP is objecting to this
Maintainability, yes.
with maintainability, then he should come up with proper material, and the material has to be produced by this court. So now the thing is that like if the charge now if the charge sheet has been filed, then let him come up with a short affidavit of bringing all those materials before this court, so that this court can consider all those materials and pass an order.
No, but Lordship, in the earlier read petition, paragraph 10.
See, your only objection to this is that there is no prima facie case to file this writ petition, correct? Because he's neither named in the FIR nor his name appeared in the charge sheet, correct?
Yes, that is on the merit and locus standi. But before that, paragraph 10 has to be overcome first, Lordship. This has been discussed.
That is
Paragraph 10 of the earlier judgment. He has to be named. If he is named at all, he can come back. And when he's not named, he's coming back with the same material. Paragraph 10, however, third sentence, however, since the petitioner is not present for disposal of the case on merit, and his limited prayer at this stage is to dispose of the matter with liberty to the petitioner to approach again, as and when the petitioner is named by the investigation agency. He is not named again, leave alone naming him in the FIR. He is not even named, now he is named, not even is named in the charge sheet.
If the prosecutor is right, the burden is on the petitioner to prove that he is named.
My lord, whatever he stated before the court, let it be in a form and evidence.
No, Lordship, is on the face of the report.
Yes, to make out a
How
case.
can I even approach?
Why my learned friend ED is, he's not a party. My
Even
learned friend
telling
is
me to
party.
do this is embarrassing, Lordship.
You are saying ED
The
proceedings.
standard of this honorable court should not fall as low as that, Lordship. It's on the face of the record, and I'm asked to ask me to file affidavit. Even in the face of it, I think it is.
May I go? I'm called in court number 1 in the Supreme Court. May I just go and come back?
Yes, yes, of course.
Great. Sure.
I thought that investigation is not been completed, my lord. Now what appears the investigation is completed. My learned friend
So
is very
that-
fair.
I mean, that
My learned friend
goes-
is fair, said that investigation is completed, charge sheet has also been filed, and I am not named in the charge sheet if I have understood properly. He said
So
that
only thing
his
is
case is that why you have
only thing is
come.
that you bring those things on record.
Lordship is very clear here.
No, no, clear means when, from where?
It's very clear in the record.
So you bring on record.
No. But first this has to be. That is just a second, third. First, this has to be paragraph 10 has to be overcome first, Lordship. Petition has to be outrightly dismissed on the basis of paragraph 10. If this can be overcome, then my affidavit of submission of these things will come. Otherwise,
See, I mean, the difficulty for this court is
Lordship,
that,
that in that
the
case, may it be
difficulty-
listed after 2 weeks, Lordship.
No, the difficulty for this court is
Yes.
that because this case is linked to other cases also.
Yes, Lordship.
So this court doesn't know, those materials are not.
Lordship,
before-
then in that case,
Listen. This court doesn't have those materials.
Lordship.
I mean, what exactly happened in the PMLA matter, how he has been named, how he has been linked, those things are not before this court.
Lordship.
Correct. So difficulty is that.
Lordship.
So because we are not hearing the whole,
Lordship,
all the cases together, so that I cannot gather the information from the other
Lordship,
case also.
Lordship, in that case, my humble prayer is, since the other more important cases are coming up, let this matter be listed in the motion stage after 2 weeks, or a date convenient to my learned senior friend. But to go beyond motion, Lordship, I don't know how to. Lordship, is embarrassing even to talk to my client.
My learned friend accommodated me a number of times, my lord. I am not saying only what I am praying, that my learned friend,
No,
he said,
one thing is there, like there is a problem for you to overcome.
no,
because of
that's why, see, my lord, there is no I'll overcome, because that's why I am saying the BNSS and CRPC. For that reason, I have, if you see the alternative prayer, which we have made,
that is speedy trial and
no. See, my alternative prayer was not there in the earlier writ petition. Earlier writ, but this case, earlier which the alternative prayer was not there. See at page
No, correct.
15.
Now since the charge sheet is already been
That's
filed,
what I'm saying.
Charge
That
sheet
is what
already-
I'm saying. That if I have not made this alternative prayer, I made an alternative prayer. I made an alternative prayer on the basis that there is no speedy investigation.
Now he's submitting the charge sheet is already.
Very nice, very well. So only thing is that he has to submit before the court. I will withdraw this case, there is no problem. Let him submit in 1 second, I will withdraw it. I should get a copy, my lord, charge sheet. No problem, my lord. Absolutely no problem. Very well, my lord. Very well, my lord. Copy should be given to me. I know where I stand. My learned friend is right. If I am not named, I should know it. No problem, my lord. This is what I am praying before the court.
You give me a copy?
Lordship, I have only that copy with me now.
Okay,
Yes, one Xerox copy could be one copy.
So you were not there, I mean.
Thank you. No, I am thankful, my learned friend has shown, because thankful to my learned friend. I know now where I have to now do it.
So I think you can, I mean, now you have gone through this charge sheet, right?
Yes.
You are not named there.
Yes.
So if you are not named there, if you are not there in the FIR, the only thing is that you have to fight it out before this, on the PMLA complaint. This goes, so you have a better
If
point
this
to argue
goes,
now.
no, I know, I will not say too much. It goes, then what happens to other case? I
So,
also know.
that you have a better point to
Yes,
argue.
yes, yes, of course, my lord. So let this matter, my lord, I'll just go through it. Let this matter come tomorrow, one copy may be given to me, my lord. So that tomorrow I can just take advice from her and accordingly, if necessary, I will withdraw this case, no problem.
I think your local council already has
My
a
local
copy.
council, I don't get the opportunity, that's why sorry. to
Let him
trouble.
have it, so we'll
Okay,
fix it
okay.
tomorrow, we'll fix it tomorrow.
Okay, okay.
We'll fix it tomorrow.
But once I get it, once I go through it, and if I find that no, there is nothing remains in this case, because in view the investigation completed, charge sheet has been filed, then I will not press this application. This is what?
So,
Just Xerox it,
you give
copy.
a copy of that to the court and give a copy to him also.
Lordship,
Sir, only one,
During the course of the day, you can give it.
your lordship will just record that submission,
No,
that
I'll
charge
do,
sheet
that
has been
I'll do,
filed, yes.
that I'll do.
No names appears.
Heard Mr. D. Das, London Senior Counsel, appearing for the petitioner, assisted by Mr. S. Das. S. Das, the Learned Counsel, Learned Counsel. Yeah, this is an application under under Article 226 of the Constitution of India, read with 528 of BNSS 2023. In connection with the investigation carried out by Nagaland Police in connection with FIR number 3/2022 dated 8/10/2021, registered at Cyber Crime Police Station Kohima, Cyber Crime Police Station Kohima. The primary prayer mentioned in this writ petition, and in this petition, is that a writ of mandamus was prayed for, declaring that no case exists against the petitioner in connection with the criminal activity being subject matter of investigation in Kohima Cyber Crime PS case number 3 of 2021 under sections 120 in bracket B stroke 420 IPC, 1860, read with section 66D of the IT Act. The learned senior counsel appearing for the petitioner submits that by an order dated 25/7/2024 passed in WPC CRL stroke 6/2023, this court has given liberty to the petitioner to approach this court again for appropriate remedy as and when the petitioner is named in the as and when the petitioner is named by the investigating agency in connection with Kohima Cybercrime PS case number 03/2021, which is now under investigation. The learned senior counsel submits that though the case was filed in 2021, till date no notice of appearance has been given to him, issued to the petitioner. shipped to the petitioner. In view of the aforesaid, he submits that since, in view of the aforesaid, the petitioner, the learned counsel submits that since the case has been registered more than 3 years back and investigation is yet to be completed, no fruitful purpose will be served in continuing with the case against him. Full stop. However, during the course of hearing, the learned PP appearing for the respondent submitted that the investigation in the matter has already been completed by way of filing a charge sheet. Charge sheet dated, charge sheet number and date.
Lordship, 25/6/2025, Lordship.
Charge sheet number
3/2025, Lordship.
325 dated so and so. So and so. He further submits that since the name of the petitioner has not appeared in any complaint, and then since neither the name of the petitioner has appeared in any complaint filed later on, nor his name appeared in the charge sheet, there is prima facie no case for the petitioner to file this application before this court. Accordingly, the PP has submitted a copy of the charge sheet that has been submitted before this court, which is kept on record by marking X. You give me a copy, marking X. The learned senior counsel appearing for the petitioner petitioner submitted that since a charge sheet has already been filed and copy has not been served to him, he may be allowed to be served with a copy of the charge sheet, and after perusal of the and he should be allowed some time to go through the charge sheet and thereafter to make his submission in the matter. In view of the aforesaid, he prays that the matter may be listed tomorrow.
Yes.
Matter may be listed tomorrow so that he can go through the charge sheet as well as take proper instructions from his client to submit before this court, to which the learned PP did not object to. Accordingly, let the matter be fixed tomorrow for further consideration.
Motion.
For further consideration.
Deeply okay.
So let him come up with his instructions tomorrow.
Yes, Lordship.
Then we can consider it.
For admission, item number 2.
Excuse me, I'll just get up for 5 minutes. 5 minutes, I'll get up and come back again. किसी को बुलाना? I'm just rising for 5 minutes. I need to come back again. Yes. Everybody is appearing in the matter? You are appearing?
Yes, Your Honor.
Yes.
Your Lordship, I'm further respondent.
Yes.
Appearing on behalf of the Consul Vivek. Your Lordship, the senior consul has some difficulty today, so if it can be listed after 3 weeks.
Item number 3,
Item number 2, Your
item
Honor.
number 2. MS so-and-so, learned counsel appearing on behalf of Mr.
Vivek.
So-and-so submits that Mr. So-and-so is unable to appear in this matter today. Therefore, she prays that the matter should be adjourned.
After 2 weeks.
The matter should be adjourned today and prays for the matter to be listed after 2 weeks. 2 weeks, the learned counsel for the petitioner doesn't have any objection.
Yes, Your Honor. Yes, Your Lordship.
Let the matter be fixed after 2 weeks.
Bless your Lordship.
Much obliged, Your Lordship.
For admission, item number 3.
This matter is a complaint in an ED case where we file a question. Now today a charge sheet has been filed. So let this matter be listed tomorrow so that I can, because now the complexity will be changed.
Okay.
ED, I think counsel is there. My friend Raju appears, but he is.
So where is the PP?
So ED is also counsel, local counsel is also here.
So let the matter be called after some
Yes,
time?
yes, yes.
So let them call.
For admission, item numbers 4 and 5.
These other 2 matters, this 6 and 7 are also linked?
May it please Your Lordship.
Yes.
Your Lordship, I'm for the respondent claimant number 1. Lordship,
Yes.
here in this IA, I have filed the objection. However, due to some technicalities, it was rejected, Your Lordship. So I may be given 3 weeks' time to refile the objection, Your Honor.
Earlier also you have mentioned that. You have not, I mean, resolved the issue.
No, Lordship.
No objection, Lordship.
Mr.
Imti Wapang, Lordship.
So-and-so appearing for the respondent's claimant submits that he had filed the objections, but the same was rejected due to some technicalities, and therefore he prays for some more time so that he can resolve, he can clarify the defects. The prayer was not objected by the learned counsel appearing for the applicant. Let the matter be fixed after
3 weeks, Lordship.
3 weeks.
Obliged, Your Lordship.
For admission, item number 8.
4 and 5 together, right?
Yes, yes, Your Lordship.
4 and 5.
For admission, item number 6 and 7.
But these 2 matters are also connected, isn't it?
But this is separate arising out of that complaint case.
Because you have been declared as fugitive.
One is a non-bailable warrant of arrest was issued.
But
that was stayed.
those are state, right?
This has been stayed. But all affidavit has been filed, my lord. And there are some few IAs which was filed before the trial court. That's why your lordship will please hear these 2 matters. It is important. We are the petitioner in this case. We don't want this matter should be delayed and we should get the benefit of stay. We don't want.
Okay.
There is a stay. In fact, we don't want the benefit of a stay. Finally, this way or that way, it happens, my lord.
So these 2 matters can be heard together.
Yes, yes.
6 and 7.
6 and 7.
One is
First-
the appeal for.
My
this
lord,
thing.
first your lordship will take 3 of 2025. It
Yes.
has got a connection with appeal. I think my learned friend Zoheb is there. I think they are ready with this case, I think. Let's start with 3, my lord. Item number 6, huh? 6. Move file the court.
An affidavit has been filed also.
All is complete, all complete, all complete. Dila nahi hai, you don't dila, copy dila hai. I just give a copy of the other side. 6.
This is a written submission.
6. No, this is just a gist of the.
Piece of the case.
I have given a copy to the other side. Item number 6.
So you were ready to argue this matter today?
You're not, I think the senior counsel, he will be online.
Online, Mr. Raju was there.
Oh, yes, okay.
Yes. My lord, I'll just give a brief facts of the case in this.
Yes, page 31 of my petition.
My lord, I'm seeking a short passover. I'm led by the learned ASG who just sought leave of the court, my lord. He had to appear in one Supreme Court matter. So I'm just seeking a short passover, my lord, so that the learned ASG can assist the court.
But I can start the case. I am the petitioner in this case. He can note down you are there because he will get a chance to give a reply. I am
only a short, so that the ASG is there, a short passover.
I am the petitioner in this case. I will waste our time. Let's. I've been the petitioner in item number.
Mr.
Item
Das,
number
I'm making
6.
a request to the court, sir. I'm only making a request to the court.
Only item number 6, my lord. It is item number 6. This is I am the petitioner. I can start and he can, because this will take, because I am the petitioner in this case.
So this case will take some time, it seems.
Yes, it will take some time.
We can start off probably.
I leave it to my lord. My lord, I was only conveying a request from the learned ASG, Mr. Raju. That's all. I can leave it to my lord.
How much time he'll take?
My lord, I'll just check. He's on his legs in court, but it will not take much time. We can come back in 15-20 minutes and mention the matter.
But by that time, facts will be completed. That's why I'm saying your lordship
we'll start.
Facts is completed. I said given notes, my lord. Your lordship will kindly see. I have given note to the other side also. Note. Brief facts of the case kindly. I'll just.
So we'll start now, and he will get the opportunity.
As my lord pleases. As me.
My lord, I'll just give. Kindly see the note first, my lord.
Yes.
There I'll go. Brief facts of the case. An FIR dated 8/10/2021, which your lordship has seen, court item number 1, was registered as Cyber Crime Police Station, Kohima, FIR number so and so, under section 420 so and so, read with section 66D of the IT Act against unknown accused. Investigation was initiated by the Enforcement Directorate under PMLA by ECR dated 12/4/2022. After completion of investigation, a complaint was filed by ED before the Learned Special Judge PMLA Dimapur on 22/3/2024 under section 4 of PMLA Act 2002 against the petitioner and 298 others. Cognizance was taken by Learned Trial Court on 22/3/2024. Please mark this 22/3/2024, cognizance was taken. And the case was registered as ML case number 1 of 2024. And the next date was fixed on 24/5/2024 for supply of copies. In the complaint filed by ED, petitioner was not shown as an absconder and no warrant was pending against him during investigation. The petitioner engaged counsel appeared before the Learned Trial Court regularly after receipt of summons. On 24/5/2024, petitioner was represented by his engaged counsel before the Learned Trial Court, and the next date was fixed for consideration of charge on 2/8/2024. Meanwhile, on and off date, my lord will kindly see, this is the case where I will rely that 3/2024-25, why we have filed this case. It starts from paragraph 4. Meanwhile, on and off date, that is on 2/7/2024, ED filed IA number 230/2024, seeking non-bailable warrant against the petitioner without notice to the petitioner counsel. And the Learned Trial Court was inter alia pleased to issue a non-bailable warrant of arrest against the petitioner ex parte. The said IA number 230/2024 was disposed of on the same date. My lord, paragraph 4. Lordship got it?
Yes.
May I read once or your lordship?
No, that's fine.
Yes. Paragraph 5. On 2/8/2024, the petitioner was once again represented by his engaged counsel and was shocked to learn that the Learned Trial Court wide order dated 2/7/2024 was pleased to issue a non-bailable warrant of arrest without any opportunity of hearing. As such, the petitioner filed a petition being IA number 531 of 2024 for recalling of the order dated 2/7/2024. So, my lord will kindly mark that IA 531 of 2024 for recalling of the order of 2/7/2024, which was an ex parte order. Now, on 5/9, please mark this date. On 5/9/2024, the said IA number 531 of 2024 was taken up for hearing. After hearing both sides, the learned trial court was inter alia pleased to recall the order dated 2/7/2024, passed in IA number 230 of 2024, with a direction that IA number 230 of 2024 shall be restored and reheard on 18/10/2024. The learned trial court was also pleased to pass an interim order to the effect that non-bailable warrant of arrest issued by order dated 2/7/2024 shall be kept in abeyance till the next date, that is 18/10/2024. Adding further, the learned trial court further directed that the petitioner shall be personally present before the learned trial court on the next date, that is on 18/10/2024. Can I just pause for a moment?
Yes.
My lord, I'll sum up to paragraph 6, which I have just narrated before this court. My lord, PMLA case, money laundering case was instituted, complaint was filed by the ED before the London Special Court. Now, my lord, the cognizance was taken. My lord, I will show later on how a cognizance is taken and on what basis, on the basis of judgment of Tarsem Lal, how it has to be considered. It is a summon case, summon procedure case. So, my lord, different dates, the lawyer represented the accused and personal appearance was dispensed with. Now, on and off date, on 2/7/2024, 2/7/2024 on an off date, NED files an application before the London trial court. And in that matter, my lord, IA 230 of 2024, the court passed an order ex parte. Said that no, the non-bailable warrant should be issued against the petitioner. And once we came to know, we have filed an application IA 531 of 2024 for recalling of that order. Now, the court on 5/9/2024 has recalled that order and restored to file. 3 direction was passed. One is we are recalling the order, restored to file, and number 3 is said that non-bailable warrant of arrest which has been issued on 2/7/2024 is kept in abeyance. And next date was fixed on 18/10/2024.
For rehearing of the matter.
And directing my personal appearance on 18/10/2024.
Yes.
Now kindly see 7. On 18/10/2024, the petitioner counsel appeared, informed the learned trial court that a copy of IA number 230 of 2024 was not furnished. And the hearing on IA number 230 of 2024 was adjourned till 12/12/2024, with an interim order passed earlier being extended. The learned trial court was further pleased to dispense with the personal appearance of the petitioner and with no further direction for personal appearance of the petitioner on the next date, which was fixed on 13/12/2024. On 12/12/2024, the IA number 230 of 2024 could not be taken up for hearing as the learned counsel for ED was not present in the court, and the hearing on IA number 230 of 2024 were adjourned till 13/12/2024. However, on 13/12/2024 impugn order, the learned, this is the impugn order which has been put to challenge in 3 of 2025. The trial court, instead of hearing IA number 230 of 2024, mechanically proceeded to direct that the earlier NBW, which was issued by the order dated 2/7/2024, against the petitioner be executed on the ground that the petitioner has allegedly violated the direction for personal appearance, which was passed by the order dated 5/9/2024 in IA number 531 of 2024. The learned trial court completely overlooked the fact that the direction for personal appearance by the order dated 5/9/2024 was specifically passed for the next date, which was fixed on 18/10/2024, on which the personal appearance of the petitioner was dispensed with and no further direction for his personal appearance was passed on 18/10/2024 or 12/12/2024. Being agreed by the said order dated 13/12/2024, passed by learned trial court, petitioner has preferred this instant revision petition. Now we will broad points of argument on law. We'll argue on this particular point, fee. But now before this, my lord, before going to the broad points of argument law, I will just show before this court my documents, which we have mentioned by brief facts of the case. Kindly take up now 3 of 2025. 3 of 2000. Now kindly take up.
Yes.
So that my brief facts of case connects with the documents. Now my lord will. My lord will kindly see at page 34. Before taking the impugn order which we have put to challenge, please look into the impugn order. Kindly note down at page 29 is the impugn order. Impugn order is at page 29. I'll show later on. That is 13/12/2024, which has been put to challenge by way of this revision petition. Now first see page 34. Page 34. Kindly see the date, 22/3/2024. On the right hand side, kindly see ML money laundering case number 1 of 2024 were registered. My lord will kindly see on the top in the Court of Special Judge PMLA Dimapur, Nagaland.
Yes.
Now this is the first date, 22/3. Now see the third paragraph. A complaint under section 44 and 45 of the Prevention of Money Laundering case is received along with the report of investigation in the form of charge sheet for the offence made punishable under section 4 PMLA 2002 against the accused Mr. Bhupesh Arora and 298 others. Please mark this. Bhupesh Arora is the petitioner before this court. I am not representing any other 298 others. Now see the next paragraph. From the perusal of the charge sheet, normally it is not charge sheet, it is said a complaint, my lord. In other case, other than this, we normally say charge sheet, but here we say complaint. And this is because why, my lord? It is under summon procedure. It has been dealt by the Supreme Court in one of the case. This type of case, PMLA is how is to be dealt. Because these are summon procedure. So it has been dealt, 2024. Now I will show the next. From the perusal of the charge sheet and accompanying material placed on record, there being a prima facie case, cognizance is taken for the offence of money laundering and the case record is taken into file. Register case as money laundering case, issue summons. Now kindly see this is why. Summon procedure. Issue summon to all the 299 accused persons, inclusive of Bhupesh Arora, who is the petition, made returnable on 24/5 for supply of copies. Therefore, it taking necessary steps. Now, kindly see the next date. These are important, relevant, that's why I am showing. Page 35. This is the next date, 24/5/2024.
Yes.
Now, my lord, 34, cognizance was taken. Your lordship was taken, cognizance has been taken. Now, kindly see 35, on the next date.
Yes.
24/5/2024. If you see para 3, Hemant Shah, learned counsel for the accused number 1. Accused number 1 is Bhupesh Arora.
Yes.
2, 3, 4 and 5.
Yes.
So and so, so and so. All these accused who is representing the counsel is been mentioned here.
Correct.
Now if you see 36, now see 36, my lord, page. The order continues. Learned counsel for ED is present along with the IO and they are to furnish copies of the learned counsel for the parties for argument on charge on 2/8/2024. Now, my lord, I will tell your lordship one thing before that. He didn't object to non-appearance of accused number 1. He didn't object. No objection was made by the ED on that particular date that why the accused Bhupesh Arora has not appeared before the court. No objection. And the court also did not warrant also that this accused should appear before the court. Now kindly see.
I think all the accused appear.
represented through the respective council.
Council, only probably one or two.
Oh, yes. But, my lord, the ED did this. Why I am linking up this particular, I am showing that at no point of time the ED has sought. Now, on an off-date day files an application. They did not sought any appearance of the personal appearance of the accused because it was represented by the council as summon procedure case, your lordship knows. It is permissible. I will show it. It is permissible. Now, kindly see. Meanwhile, so and so, for hearing on exemption application on 7/6/2024, copies supplied in the form of so and so, further issue summon to rest of the accused person, ED to take steps accordingly. Right, my lord?
No, for further issue summons to the rest of the accused person. Okay, for the rest of the accused.
Yes.
And for hearing of exemption application on 7/6/2024.
Only, my lord, at page 35, these are the person who appeared represented by the.
Correct. So for other persons, for summons have been
yes,
to be
right,
issued.
right.
And 7/6 has been fixed for exemption.
Yes. Now, I-8, 370, 371, 372, 221, so and so for accused petitioner, none appear for the ED. Lordship has seen, none appear for the
Yes,
ED.
yes, on 7/6.
Yes. Now, see page 37, goes on, all the council who appears.
Yes.
Now, see the last two lines. Application for exemption accused number 1 and an application hearing of the case in hybrid mode will be heard separately. So, my application for exemption and hybrid mode will be heard separately. Now, if you see at page 38.
So all the other cases are fixed on this thing? Are fixed on 7/6/2024?
Yes, yes,
But,
yes.
But your case.
My application for hearing of the case, there's exemption application, my lord.
So will be heard on the same date or different date?
Will be heard separately,
Separately?
but yes, it doesn't reflect. Now kindly see, heard the argument, they have heard. The argument of learned counsel matter is part heard.
Okay.
YP Gupta, learned so and so for the ED makes his subsequent appearance and files his written reply to the application, also make his submission. The order is kept reserved.
Okay, so the matter was heard?
Yes, but it is kept reserved. It appears here.
Yes.
Now 2/7/2024. Now kindly see, this is what has, my lord, is an outcome of this 3 of 2025. Now kindly see 2/7/2024. IA 230 of this is very relevant. Please mark it 2024.
Yes.
Now present YP Gupta for ED, heard the learned counsel and the order is kept reserved. Now the petitioner was not present, he can't be present because it was an off date. It was an off date. My lord, if your lordship seeks again on page 36, again 35 is 24/5/2024, 35, second date.
So for exemption application, it was fixed on 7/6.
Yes, but see page 35 again.
yes.
This is the second date, 24/5/2024. You see at page 36, argument on charges on 2/8/2024. So it was fixed on 2/8/2024.
It was fixed for charge.
Charge
But for exemption, it was fixed for 7/6/2024.
2024.
7/6.
Correct,
In
right.
7/6, the matter was non-appear for ED, but,
Yes.
but your application was heard.
Yes.
Your application was heard. Your application was part heard.
Yes, part heard.
As for this,
Yes.
matter is part heard.
Y Gupta so and so makes his submission appearance and file written reply to the applicant and also makes his submission, the order is kept reserved.
He makes his subsequent appearance and files his written reply to the application.
Yes.
It is your application or somebody else's?
Which application?
This is your application.
Yes, my application.
Your application and
Yes.
also, because the matters are taken together, no? All the
Yes,
matters.
yes. My
So,
application.
Your application and makes his also to make his submission, okay.
Yes.
Then 2/7/2024, according to you, it was not
It was
reflected
a-
in the order that it has been
2/8
fixed.
2/8 was fixed. 2/7
2/8 for charge.
for charge, but
But,
there is no
exemption-
date. There is no date as 2/7/2024.
Correct, but the thing is that
Yes.
exemption application hearing happened on 7/6.
Yes.
And 7/6 order does not reflect that the matter has been again fixed on 2/7/2024 for
Yes.
further hearing or whatever.
Yes, right.
Correct.
2/7/2024, this is an update. The matter has been, it was heard by the, ED has placed it before the court, and accordingly the order is kept reserved. So application has been filed by ED for issuance of a non-bailable warrant of arrest, and accordingly it was heard, and if your lordship kindly see,
So, but this doesn't reflect that this application has been filed
which application?
for non-bailable warrant.
No, my lord will kindly see at page 60, the order has been passed.
Page 60.
60. I will show later on to it.
Okay, correct.
It will be easier
So,
to connect
so
it.
according to you, 2/7 was not fixed.
Now, please see page 60 now of 2/7/2024, which has been kept reserved
Page 60.
by virtue of 2/7/2024. If you see page 60,
Yes.
kindly see date of the order.
2/7/2024.
Yes. Lordship got it?
Yes.
And see the IA on the top
2/30.
of 2024. Right, my lord?
Yes, yes.
Yes. Now kindly see. See at para 02. Your lordship will find it para 02. The instant application of section 70 CRPC read with section 65 Prevention of Money Laundering Act is filed by complaint applicant, the directors of enforcement through his assistant director Dimapur, praying for issuance of open-ended non-bailable warrant of arrest against the accused Bhupesh Arora. This is what your lordship is saying. Where is that? This is what they have filed, his application for open-ended non-bailable warrant against the accused. Mr. Var, that application is not with us. The application which they have filed it. Now, kindly see this narrating the facts. I will not trouble, your lordship knows by the time. If you see at page 61, the second paragraph, the learned special public prosecutor submits that under section 52 of PMLA dated 13/1/2023, 23/2/2023, 15, 27/9, 18/12 and 21/2/2024 were issued to the accused Bhupesh Arora, but he never appeared before the investigation agency. So these are the dates, few dates where he was summoned, but he never appeared before the investigation agency. Even the order dated 25/9/2023 of the Honorable Gauhati High Court cooperate with the investigation was not complied by the accused. I just pause for a moment here, because earlier round, your lordship has seen, there are few cases which was filed. We have prayed for some that no coercive measure should be taken in the case, in money laundering case also. So court say very well, we will protect you, no coercive measure, but in the meantime cooperate with the investigation agency. What they came up, when the complaint was filed before the court, before the trial court, and 2/7 that particular application was filed for issuance of open-ended non-bailable warrant, these are the few grounds which they have mentioned. Look here, this is the type of person. Some protection, we summoned him, even he didn't appear. There was an order from the court, even he didn't appear. So this was basically, they argued the matter.
Of the grounds they have made out.
Yes,
for that.
some grounds they said that.
They tried to make out. And
Yes,
they
but my lord will kindly see, please note down, this is not an ex parte.
This order,
Even, my lord, now you see, my lord, even the order dated 25/9/2023 of the Honorable Gauhati High Court at page 61. Page 61. Even, this is the second paragraph reading, even the order dated 25/9/2023 of the Honorable Gauhati High Court Kohima bench to cooperate with the investigation was not complied by the accused. It is submitted, accused is evading the investigation, deliberately not joining the investigation, and is presently absconding. It is also submitted the presence of the accused is required by the investigating agency for collecting evidence and also pertinent information which is within his personal knowledge and exclusive domain. The non-cooperation of by the accused is delaying the proceeding, and there is reasonable apprehension that the accused is trying to alienate his movable asset and tamper with the evidence, and it is believed that the accused is presently absconding at Dubai. As such, the learned SPP submits that all possible efforts to secure the presence of the accused before the investigating agency has failed due to his non-cooperation, and prays for issuance of open-ended non-bailable warrant of arrest against the accused. Now, I have considered the above submission advanced by learned so-and-so for the applicants. The perusal of the ECR shows that there is a prima facie case against the accused Bhupesh Arora for the offences as alleged against him. As submitted by learned SPP, the record shows that summon under section 52 PMLA was issued to the accused on 6 dates, but he never appeared before the IO. Though he did not respond via email to summon dated 23/2/2023 and 18/12/2023, citing medical reason, and to the last summon dated 21/2/2024, praying for a few weeks' time, he never appeared before the IO. Even the order dated 25/9/2023 passed by Honorable Gauhati High Court at Kohima bench in the writ petition filed by accused White, criminal WPC criminal number 3 of 2023, wherein the accused was directed to cooperate with the investigation, was never complied with by the accused. Now, 3 of 2023 has been withdrawn earlier, my lord. As such, from the aforesaid, I am satisfied the accused is not cooperating with the investigation, and that his presence before the investigation agency is necessary, and now it is shown accused is absconding and stationed at Dubai. Prayer of the applicant is being allowed. Accordingly, in view of the aforesaid reason as stated, instant application is allowed, and an open-ended non-bailable warrant of arrest is hereby issued against the accused Bhupesh Arora, son of so-and-so. With the above observation and direction, instant IA number 230 of 2024 stands allowed and disposed of accordingly. So this is the order, my lord, an ex parte order which was passed by this court.
But what about these dates like 13/1/2023, 23?
Now, kindly see. Now we see just this order I have read. Now see, your lordship wanted a connection in between. Now see paragraph. Which page? Page 7. Kindly see. Page 7 of my.
Yes.
Page 7 of my petition. Page 7, paragraph 9. 9. 9. Yes. 9 and 10. Kindly see. In the integral, the respondent filed an application being IA number 230 of 2024. Inter alia praying for issuance of an open-ended non-bailable warrant of arrest against the petitioner. Learned trial court did not serve any notice whatsoever of the purported application on the petitioner or his advocate. Petitioner did not have any knowledge or notice whatsoever of the said application or the date of hearing thereof. On 2/7/2024, learned trial proceeded to hear the IA number 230 of 2024, ex parte, and reserved the same for order. On the very same day, that is 2/7/2024, learned trial court with a closed mind and in a most mechanical manner allowed the said application, issued an open-ended non-bailable warrant of arrest against the petitioner herein. Petition, this is what, my lord, is there. Now, it is a response, if your lordship looks into it.
How come this 15, page 59, page 61.
Yes.
Now, how come the learned SPP submits that summons under section 52 PMLA, dated so-and-so were issued to the accused Bhupesh?
That is,
when the counsel was present.
This was at the time of investigation. My lord, one is post-investigation, one is pre-investigation. My lord, I'll show one judgment that will make very clear. Once it is before the court and cognizance is taken,
then it's a different matter.
ED doesn't have any power. ED doesn't have a power to investigate the matter. It is only through the court. Whatever the court has to pass, it becomes under the custody of the court. Court has to do it.
So their basic allegation is that
this is.
No,
my lord, will kindly note down. The charge sheet was filed 22/3/2024.
Charge sheet when?
22/3/2024. Complaint.
22/3?
Yes. 2024.
24.
Yeah,
so these dates 13/1 30, 23, all 23 dates, okay?
All these are prior.
Prior.
Yes.
So like, in fact, the submission was that he did not appear before the investigating authority, not before the court.
Yes.
Correct?
During investigation. 34, your lordship has seen that, page 34, kindly see 34 of
That
the,
cognizance was taken on.
on 22/3/2024.
Correct. So
And
all these dates
all
were
these dates were prior to that.
Prior to that,
Not-
and
not-
allegation was that he did not appear before the
That's
investigating
right.
authority.
No, not, my lord.
Not before the court.
Not before the court. It has to be before, not before the court. Now the ex parte order on an update, if your lordship looks into.
Now tell me one thing. I mean, if in the event of the accused not appearing before the investigating authority for many days, on many dates, whether that can be a ground for issuing non-bailable warrant or not?
No.
After filing of the charge.
No. I'll straight away say no.
Okay.
Recall করা দেখাইতে no. My lord will kindly see, this order is now been recalled. 230 of 2024 has been recalled by the court itself.
This has
That's
been
why,
recalled.
yes, that's what I am saying. If it is recalled, nothing to it has been recalled.
So nothing remains in this order.
Yes, kindly see, it has been recalled now. How it is recalled, kindly see.
5/9.
An application has been filed by me, IA 531 of 2024,
Correct.
before the learned trial court for recalling this order of 2/7/2024.
Correct.
Now, page 41, kindly see. Say 41 now. See 41. See page 41.
Yes.
See, IA 531 of 2024. At page to 29/8/2024.
So 5/9/2024, this has been moved.
Yes. And my lord, I have filed an application, also an off date for recalling of the order. Of course, the notice has gone, IA 531 of 2024 on 5/8/2024. Please note that, my lord, it is not there. 5/9, yes, 5/8/2024.
5/8 or 5/9?
No, this is 5/8. 5/9 maybe. 5/9 maybe.
It's 5/9.
Which I have filed my application. I filed the application before the 5/8. My lord, it is 5/8. I'll say the recalling is 5/9. 5/8 I have filed before the court. Your lordship, I'll show it, my lord. Your lordship, please note that I have filed at page 41, and on off date 5/8/2024, I filed IA 531 of 2024 before the same court on an off date. Now, that application court has now 29/8/2024, kindly see the order now, 29/8/2024.
Yes.
Lordship seen, present YP Gupta so and so, Amit Singh, learned counsel for the accused petitioner, that is the present petitioner. Written reply filed by ED and the parties praised for fixing the matter on 11/9/2024 for arguments. That is my recalling of the order. And now this, however, I do hope, now kindly see the third paragraph. So and so learned counsel issuing envelope till the next letter. However, I am not inclined to say prayer. Matter is fixed, will be heard on merits. However, I do hope that no coercive step to be taken by the investigation agency. My lord will kindly see, your lordship has seen that even the court said that no coercive measures should be taken.
Yes.
Court said, I will decide that issuance of non-bailable whether is correct or not. But please do not take any coercive measure by the, I do hope that no coercive steps to be taken by
So
investigation agency.
NBW was in existence at that point of time, but court wanted to hear it.
Yes, correct.
Because he filed an application.
Yes.
And till that time he said that no coercive
Correct,
action should be
absolutely,
taken.
right, absolutely. Now, learned counsel makes a further prayer at page 41, makes a further prayer that arguments will be preponed to 5/9/2024.
Correct.
The prayer is allowed. Now, 5/9/2024, the order has been kept reserved. Kindly see,
So
IA 531,
Hearing
reserved.
happened and hearing.
Yes, now the order, please see the order at page 63 now. Please see the order at page 63.
Yes.
IA 531 of 2024. The order is 5/9/2000. Lordship got the order?
Yes.
Date of order.
Yes.
Now, recalling is para 2, see para 3, my lord.
Yes.
See para 2. The instant application of 72 BNS is filed by the accused petitioner praying for recalling and or cancelling the order dated 2/7/2024, wherein a non-bailable warrant of arrest was issued against him. That is page 60, I read the order. It is submitted by learned counsel for the accused petitioner that after taking cognizance, summons was issued and the accused appeared through counsel on the date fixed on 24/5/2024 and the next date was fixed on 22/8/2024. You have seen the order. However, this court on the prayer of the ED has issued the impugned order dated 2/7/2024. Learned counsel submits that the accused petitioner was not arrested during the course of investigation and the ED cannot pray for issuance of non-bailable warrant of arrest against the accused petitioner without showing him as an absconder. As such, the learned counsel prays for recalling and or cancelling the non-bailable warrant of arrest issued against the accused petitioner. In support of his argument, the learned counsel relied on the decision of Tarsem Lal versus so-and-so and this line. Now see the Tarsem Lal judgment, my lord, 30. This is 2024, 7 SC, page 61. I'll read details. But see, para 30 has been quoted by the learned trial court, which was cited by us. Once cognizance is taken of the offence punishable under section 4 of PMLA, the special court is seized of the matter. After the cognizance is taken, the ED and other authorities named in section 19 cannot exercise the power of arrest of the accused shown in the complaint. Reason is that the accused shown in the complaint are under the jurisdiction of the special court dealing with the complaint. Therefore, after cognizance of the complaint under section 44(1)(b) of PMLA is taken by the court, ED and other authorities named in section 19 are powerless to arrest an accused named in the complaint. Hence, in such case, an apprehension of the ED will arrest such an accused by exercising power under section 19 can never exist. In director of so-and-so, now this I just leave this, but Tarsem Lal is important. Some judgment I have cited.
No,
Now,
Mr. Das, I mean, see, only thing is that Tarsem Lal is saying that once the cognizance has been taken, so ED cannot do anything. ED cannot arrest. ED cannot arrest, but in the instant case, that NBW was issued by the court, not by the,
correct,
not
right.
by this. So how Tarsem Lal is applicable?
no, I'll show. Why Tarsem Lal broad parameters has been given. What happens when a complaint is filed before the court, how the procedure has to be followed, all this has been laid down. Now, my lord will kindly see. Now, further, your lordship will kindly see
why this paragraph is relevant. I could not understand.
I'll show it, my lord. See, this way I explain. See paragraph, page 66, my lord.
Page 66.
Yes. Finding of the court at page 66.
Yes.
Paragraph 3.
Yes.
Tarsem Lal, my lord, I have considered, kindly see 05. 05 on top.
Yes.
I have considered above rival submission advanced by learned counsel party. It is a fact as pointed out by learned counsel for the accused petition that the present accused was not shown as absconder in the instant complaint. It is also a fact that application for ED praying for open-ended non-bailable warrant was heard without giving any opportunity to the accused petitioner. Lordship got it?
Correct.
In Tarsem Lal of the Honorable Supreme Court at para 31 held as under, if ED wants custody of the accused who appears after service of summons for conducting further investigation of the same offence, ED will have to seek custody of the accused by applying to the special court. After hearing the accused, the special court must pass an order on an application by recording brief reason. While hearing such an application, court may permit custody only if it is satisfied that custodial interrogation at that stage is required, even though the accused was never arrested under section 19. This is the reason.
Correct.
So, my lord, it cannot be number one, it cannot be an ex parte order. Tarsem Lal say, if any application has to be filed by ED, a notice is mandatory to be given to the accused. After hearing him only, necessary order can be passed. I'll show the judgment. What has been done in the instant case, my lord? 2/7/2024 was an off date. They file an application for issuance of a non-available warrant of arrest against the accused. Without hearing, without issuing any notice, my lord, an order was passed by the
That
court.
is clear. That is clear
That
that,
is clear.
an ex parte order was passed,
So-
and your basic submission is that you have not been heard, you have not been given a notice. So the whatever the order has been passed in the application of the ED, praying for non-bailable warrant is not correct.
Yes, now, my lord, this is what the learned trial court makes now observation. See, in the instant case, the accused petitioner was not arrested during the course of investigation, and he was absconding and evading arrest as claimed by ED. Now kindly see, as claimed by ED. But he was not shown as absconder. But be that as it may, the ED can still stick custody, even though the accused was never arrested, but hearing the accused, as per Tarsem Lal Supra. Your lordship got it now, my lord?
So that is the ground, yes.
Yes, as noted above, kindly see, as noted above, the application of the ED praying for open-ended non-bailable warrant of arrest was heard without affording an opportunity to the accused. As such, I am of the opinion that the application of ED praying for open-ended non-bailable warrant of arrest be reheard, giving an opportunity of hearing to the accused petitioner based on Tarsemlal judgment.
Correct.
See, the application of the ED will be reheard. So a few direction was given, kindly see, my lord. On the next date, returnable, which is fixed on 18/10/2024, ED to supply a copy of their application to the accused petitioner through counsel, that is 2/7/2025, of that they filed an application to be supplied. ED to, meanwhile, my lord will please mark it. Meanwhile, non-bailable warrant of arrest issued against the accused petitioner, namely Bhupesh Shara, is kept in abeyance till the next returnable date. Next returnable date is 18/10/2024. The accused petitioner, my lord will kindly note down, is to be personally present on the next day. Next date is fixed on 18/10/2024. And then this application of ED is IA 230 of 2024. My lord, the application of the ED will be reheard. That is IA 230 of 2024. So, my lord, basically there were four directions. Court said that yes, you can file an application, absolutely no problem, by the ED before the trial court.
Correct.
As the judgment of Tarsem Lal said,
So you'll have to give a hearing.
you have to give a notice first, then a hearing. What you have done in this case, without giving a notice and without hearing, an order has been passed ex parte, which is violation of Tarsem Lal judgment. So that is the reason why the court interfered. And this is very important.
A notice by whom?
I'm sorry?
Notice by the court or notice
From the
by,
court, notice by the
notice by the
court.
court.
Notice
so
by the
so
court.
now by this order notice has been given.
Now by this order, my lord, notice has been, we come to know now, notice has been given. Now, what has happened at 2/30 of 2024? Whether it has been heard, till today it is not been heard.
Not being heard.
It till today.
Because it will be reheard again.
Now, what led to come up before this court, challenging the order of 13/12/2024? That's the whole issue. 13/12 is the impugn order which has been put to challenge.
Yes.
Now your lordship has gone to 5/9/2024, the order. Now kindly see 18/10. First see the 18/10 order, whether there is a compliance. Because the court has fixed on 18/10, lordship has seen that. So
1810 you could not appear. You
now
appeared to a counsel.
18/10 I appeared. Kindly see at page 42.
Page 40.
2. See page 18/10 order. Court said that next date has been fixed on 18/10.
Yes.
Right, my lord?
Yes.
Till then, the matter will be kept in abeyance.
So 1810 order is 42. Yes.
Yes, page 42. Now kindly see learned counsel Amit Singh present for accused number 1, that is Bhupesh Shara. 2, 3, 4 and other appear. See page 43, kindly see down below. Down below.
Correct.
For learned counsel, see Amit Singh appeared for accused number 1, the Bhupesh Shara, apprised this court that application IA 2/30 of 2024 is pending disposal, whereby the complaint has filed for non-bailable warrant for accused number 1. Learned counsel submitted copy of IA application has not been served. Learned special PP submitted before this court. Copy will be served today before this court for accused number 1, that is IA 230 application which he has filed. Let the application IA 230 of 2024 be listed on 12/12/2024. Meantime, the interim order IA 531 of 2024 shall continue till the next date. Right, my lord? Now kindly see. Yes, my lord, your lordship knows what are the direction that has been passed. Interim order means non-bailable warrant of arrest which has been issued, that has been kept in abeyance. That will continue. And my appearance on the next date, personally present, I file an application before the court, represented by the lawyer. Now, kindly see what is the paragraph, third paragraph in page 44.
Yes,
With regard to the accused person, all the accused who has been represented by the learned counsel for their personal appearance has been exempted for today. So it was exempted. All the accused, the lawyers who represent on behalf of the accused, their personal appearance has been exempted for today.
Correct.
Including, my lord, will be of course Bhupesh Shara, inclusive of Bhupesh Shara, because Amit he represented. Now, my lord, issue bailable warrant to the accused who has not appeared. Issue bailable. Now, fixing on 13/12. Kindly see, my lord.
Yes.
Fixing on 13/12/2024 for appearance.
Correct.
This is a normal course, my lord, business course of hearing which is fixed on 13/12. But IA to be listed on 12/12. My lord, will kindly see on top. They will supply a copy to us and IA will be heard. They will give a copy to us. It will be heard on 12/12. And normal course of the case is fixed on business is fixed on 13/12/2024 for appearance. Yes, sir. In others, my lord, so far as other accused are concerned, bailable warrant was issued, my lord. Now, kindly see now what they have done. My lord, now we will not, your lordship will not go in 24/10. Please go into next, my lord, 12/12 at page 46. Then it will be easier to connect. See page 46.
Yes, 12/12.
Page 46. 12/12/2024. Right, my lord?
Yes.
Learned proxy counsel so and so present on complaint and ED. So somebody appears on behalf of ED. Learned counsel C. Amit Sir present for accused number 1, that is Bhupesh Shara, and file an application for directing the proceeding against accused number 1, assailing the orders of Honorable High Court in WPC 26 of, my lord, this is which is item number, you have watching quashing of the complaint. Also prays for time to file a reply of IA filed by the complaint. Since the principal counsel for the complaint is absent, ED was absent, let the IA also be taken up tomorrow along with the main complaint case.
On 13.
On 13.
Yes.
Now, on 13/12/2024, it will be listed for hearing that IA 230 of 2024.
Correct.
Now, what has happened on 13/12/2024?
Yes.
This is a challenge which is made by way of a revision petition before this court. This is the order which is impugned and this is a petition.
So 13/12 order is at page?
Page 29.
29.
See the order of page 29.
Yes.
13/12/2024.
Correct.
Learned SPP YP Gupta, learned SPP present for complaint. Now see, this paragraph is most important. Learned counsel Amit Singh present for accused number 1, 2, 3 and 4 and also file exemption application for accused number 1, 3 being IA number 920, 921 and 2024. So, my lord, the counsel represented by Amit Singh and he files an application.
For exemption.
So far as Bhupesh Arora is concerned, for exemption application IA 920, my lord, was filed.
Yes.
920. And rest he has filed 920. We are concerned of 920. Since, now kindly see what is the observation made by learned without going through others. Since with regard to accused number 1, that is a Bhupesh Arora, this court has filed order dated 5/9/2024. Your lordship has read that order?
Yes.
While disposing the IA, it should be 531, my lord, of 2024, directed the A1 to be present in the person. However, A1 has failed to comply with the direction of this court. Hence, non-bailable warrant issued against the A1, which was kept in abeyance, be executed with regard to so and so, so and so, so and so. So this is what we are agreed. Now, what the learned trial court do it? 13/10, when the matter came up, we were ready with the hearing of this case. Before hearing of 230, we said I have filed an application 920, please exempt. Now that court said that will be taken afterward. First,
Was
what
there
we
any
are
order
saying,
passed in that?
no.
920?
No.
No order was passed.
No order.
Nothing, it was not
Nothing,
considered.
no order was passed. 920, 921, no order has been passed. Court was not concerned about that. Court was more concerned about 5/9/2024. Court has said, what I have understood by reading this 6-7 line,
This court has directed to appear, you didn't.
you
appear.
did not, so there is a violation of the court's order.
But in that order also, he has mentioned that like he's been exempted.
This is the whole case. My lord, 5/9/2024, there were a few directions. He said that you have violated direction. What we do is, non-bailable warrant of arrest, which was kept in events, will execute. This is what he passed on 13/12/2024.
Yes, yes.
So I have come up before this court challenging that order. So there are few legal issues. Apparently, on the face of record, I have shown the order 1810. After 5/9/2024, there is an order of 1810/2024. I have read that order. What is 1810/2024? Amit Singh appears. Other counsel appears. Now, the application IA 230 has not been served to us. Court said, serve this application IA 230.
And we'll hear it.
And in the meantime, the interim order of that 5/9/2024 will continue till next date, fixing 1810/2024. In the meantime, the personal appearance of all the accused who represented by their counsel exempted. So if it is so where is that further direction that personal appearance that the petitioner has to appear, the Bhupesh Arora has to appear before the court? No further direction given by the court. 1810, there is no further direction. Only it is exempt. Because why? Why I'll tell the reason is that when a case of 12/12/2024 to be heard on an IA 230 or 2010, it is between lawyer. When the court when they call an accused before the dock, a charge has been, now they will framing of charge. They may call the accused, yes, the accused has to be present. It's a prerogative of the court. And the court felt IA 230 of 2024, it is between the two lawyers. Well, where is the question of connection? That is why that direction was not given. So now what the trial court on 13/12/2000, with great respect, makes mistake. He says that 5/9/2024 you have violated. Where is the violation? My lord, my violation cannot be.
Violation could have been, he could have probably recorded it if it would have been a violation.
Now
considering
now
the personal
I'll
appearance
tell
has been
two
given,
few
but
things,
it has been exempted.
which I have a personal experience in the learned trial court. I'll take 2-3 experience. My lord, when a normal course, when in a summon case, when a complaint is filed. Now, when a complaint is filed, my lord, examination is taken on oath on a complaint. Now, if the court feels that a summon to be issued, summon is issued, your lordship knows it starts from 200 to 205. Dispense is 205. Now, when the court says that yes, I have recorded, I am satisfied, cognizance is taken, summon is issued. Now, steps has to be taken. Steps has to be taken by the complainant.
So
through court.
But otherwise in PMLA, there is no separate procedure other than this 200.
This judgment of the Supreme Court, 200 to 205.
is applicable.
Yes, right. Now, why I am saying that legal point I will show before this court what are the points which you are raising. Apart from this 13/12, apparently it is bad. Apparently it is bad. Now, my lord, apparently it is bad. This order itself is bad. On the face of it, your lordship has looked into it. So this order could not have been passed. Today, what the ED should have done it. Forget all this case. What we'll do it? Go before trial court, rehearse that IA 230. All this will be solved. 230 or 230 will be solved. Now, this is our advantage. They are filing one after an application before the High Court.
But the proceedings, I mean, the effort, NBW is in state, right?
Yes, it is state. It is state. No, I'll pause for a moment. I am just digressing myself to some application which they have filed before this court, only to nullify a stay order passed by this High Court. High Court has passed the stay order. After passing of a stay order, the ED goes before trial court, moves an application before the trial court or BNSS that please give a direction for production warrant so that we can arrest this person. Now that also without giving any notice, after stay order passed by this High Court. We challenge this before this court. ED appears, court hears the matter, set aside this order. You cannot do it because the High Court states that order of 13/12/2024. My liberty is protected. You cannot come with any other application to nullify the order of the High Court. This is what we projected. It was, my lord, a battle in the court, and they said, no, this is what has happened. How can it be done? Court hears the matter, set aside the order. This is gone. When it is set aside, what they do is, they say that we will move these two matters before the Supreme Court. Challenging this order, 90 days has crossed. They doesn't move it till today. Not moving before Supreme Court, again they go for trial court. Again they go for trial court by the ED. They file another application. Another application they file that no, under section 19, please give this order so that we can arrest this accused. Once we came to know that this application has been filed, immediately we came before this court by way of 33 of 2025, which is before this court. And we said, what is they are doing, trying to do it? One hand, there is a stay order which has been granted. One hand, there is an order which has been passed by the court. Earlier round of litigation, the production warrant is set aside. Again, you have come up under section 19. It is barred by res judicata. We said, how can it is barred by res judicata? And this has been stayed by this court. So what I was saying in the morning, that I want to finish it, my lord, this way, that way. This may go favor against. But, my lord, there has to be a logical conclusion of these two matters. My lord, today what? I am being benefited. They are filing one after another application, harassing us. So why not to hear this matter? It will be ended. Today, simple, my lord. Today it goes before London Trial Court. 2:30 will be heard, and London Trial Court will decide whether to issue a non-bailable warrant or not to issue a non-bailable warrant. What they wanted? They wanted that 27/2000 then application file, issue a non-bailable. That has to be heard because London Trial Court said that we'll rehear this matter. Till today, my lord, it has not been reheard. Till today. And we are fighting all this battle before the court.
That hasn't been disposed of,
They have not been disposed. Now, my lord, will 920, my personal appearance exemption has not been disposed. 2:30 of 2024 has not been disposed of. Your lordship has seen on the face of it, there is no violation of the court's order. Because on 18/10/2024, my personal appearance was exempted. Thereafter, there is no order where I have to be present. And on 2/8/2024, now, my lord will kindly see the stage of the trial. Stage of the trial at page 39. See the stage of trial for a moment. See the stage of trial at page 39. I'll just read this. 2/8 to the stage of trial. 2/8. By this instant accused applicant, my exemption application 506 on 2/8/2024. By this instant application, the accused applicant Bhupesh Chawra is seeking his exemption from personal appearance in the court today. Heard learned counsel peruse the record. Considering the accused is represented by his counsel and the instant matter is the stage of supply of copy and scrutiny of document, wherein the presence of the accused is not necessary. What, my lord? One and the court is saying the instant having allowed and the accused applicant who is hereby exempted from personal appearance in the court for day. See, my lord, what is the stage? And the subsequent date also my personal appearance exempted and my lawyer appeared throughout till 1810. And today my law stage is same, supply of copies. Charges, they cannot frame charge because 299 accused.
Charge sheet not filed, is it?
No, but they have not framed. Charge sheet has been filed. Complaint has been filed. Charge has been filed. But charges not framed. No, the stays on 2/8/2024, it remains the same. If it remains the same, my lord, and in a learned trial court said that my personal appearance, my personal presence is not required, so why it was so necessary that my personal appearance required? You file an application on update on 2/7. Kindly see, my lord, kindly see, connect this date 2/8/2024. On off date 2/7/2024, they filed an application for issuing a non-bailable warrant of arrest. And in this case,
They exempted you.
Exempted. And on, my lord, it was recalled. And there is no violation of the court's order. Now, what I am saying, my lord, very, very important law points. Apparently, my lord will kindly see the interim order passed by this court. Your lordship has
That I have gone through.
your lordship has gone through it. That is on
Page this thing.
21/3/2000. My lord, for your lordship convenient, my lord will kindly see, I have given a compilation
That
for your
is-
lordship convenience. No, this is list of,
Okay.
this is a compilation which I have submitted before the court.
Yes.
A compilation, see compilation, is compilation.
Ah,
Before the court.
there is one. problem.
Yes, please see. This is in top,
Comparison for, of the dates, order dates.
3 of 2024, right, my lord?
3 of,
2025.
correct.
And see the dates which I have mentioned here.
27/2 and, yes.
Yes. And internal is page number 9 of this court, where in the compilation,
This one.
see, my lord, 21/3/2025.
Correct, I have seen this. This is,
Your lordship has read, I will not trouble this court, if your lordship has read this order.
no, you can read it. Still you can read.
Yes.
The operating portion is at this
My lord, yes.
page 12.
Now your lordship will it will be easier for us.
Yes.
My lord will kindly see paragraph 4, paragraph 5. 4. My lord, he submit the instant revision. The petitioner has impugned the order dated 13/12/2024, passed in ML 1 of 2024 by learned special judge PLA Dimapur, whereby non-bailable warrant of arrest was issued against the present petitioner. The learned senior counsel has submitted that the main ground for issuance of non-bailable warrant of arrest against the present petitioner was that the petitioner failed to appear in person before the court in pursuance to the order dated 5/9/2024, passed in IA number 531 of 2024. Learned senior counsel for the petitioner has submitted before registration of IA number 531 of 2024, trial court had on an application made by learned special public prosecutor ED on 2/7/2024 in IA number 230 of 2024 had issued non-bailable warrant of arrest against the present petitioner without giving an opportunity to learned counsel petitioner of being heard. Learned senior counsel for petitioner has also submitted ML 01 of 2024 after submission of charge sheet. Summons were issued to 299 numbers of accused persons including the present petitioner. After receipt of summons, petitioner engaged counsel has been appearing before the trial court regularly. He also submitted that in the charge sheet, the petitioner has not been shown an absconder and no pending warrant was issued against him during investigation. Learned counsel, senior counsel petitioner has submitted order dated 5/9/2024 passed in IA. The trial court kept a non-bailable warrant of arrest issued against the petitioner by trial court on 2/7/2024 in abeyance and directed the ED to supply the copy of petition filed by them in IA number 230 of 2024 to the petitioner, fix the matter for hearing on 18/10/2024. By the said order, petitioner was directed to be personally present on the next day, that is 18/10/2024. Learned senior counsel petitioner submitted 18/10/2024. Learned engaged counsel for the petitioner was present in the court. He submitted before this court that as the IA number 230/2024 is pending for disposal and copy of the said IA has not been furnished to the petitioner, the court directed learned special public prosecutor to furnish the copy of the said IA and fix the matter for hearing on 12/12/2024. In the meantime, the in IA number 531 of 2024 was extended till next day. The learned senior counsel petitioner submitted as the non-bailable warrant of arrest issued in pursuant to order passed in IA number 230 of 2024 has been kept in abeyance and the personal appearance of the petitioner was dispensed with by trial court on 18/10/2024. There was no occasion or trial court to issue non-bailable warrant of arrest on 13/12/2024. Hence, he prays for staying the operation of the impugned order 13/12/2024 till the next date and also prays for keeping the warrant of arrest issued against him by the impugned order in abeyance till the next date. Considering submission made by learned senior counsel petitioner, learned special public prosecutor has submitted since the ED has sought for time for filing written objection against the revision petition. He has no objection to grant of intervening sought for by the petitioner in this case till the next day. Considering the submission made by learned senior counsel, prima facie it appears the order dated 5/9/2024 has not been violated by the petitioner Hence, till the next date fixed, the operation of the impugn order dated 13/12/2024 shall remain state, and a non-bailable warrant of arrest issued in person of the impugn order shall also remain state till the next date. List this matter again on 20. So on various dates, my lord, interim has been extended time to time. Now, my lord will kindly take my note, again note, goes back to the note now. Yes. Now, broad points of argument and law. So, up to para 10 I read, being aggrieved and the said order passed by learned, petty notes, my lord. Lordship got it?
Got it.
At page
11,
3.
page 3, sorry.
3. And see now 2. Broad points of argument and law, because we are now on the hearing stage. Additional ground, my lord. A. Procedure for trial in PMLA case is that of a summon procedure case. B. Accused entitled to be represented by engaged advocate. C. Non-bailable warrant should not be issued as a matter of routine. D. An order once recalled becomes non-est and cannot be given effect subsequently as it invalidates the entire proceeding. Now E. An order of recall under procedural review cannot be indirectly reviewed by a substantive order. So these are my broad parameters on argument of law which I like to argue on this point. First point, I'll deal A. Procedure for trial in PMLA case is that of a summon procedure case. My lord, if your lordship looks into PMLA, they have not laid down which procedure one has to be adopted. So, judgment of this, the Supreme Court came 2024. What are the parameter which should be laid down? So, please look into the judgment of Tersemlar.
Yes.
Your Tersemlar copy. Now you have to give, my lord. If this is my lord, see
23.
paragraph
3A.
23A, kindly see. For certain paragraphs I have to read that, no, otherwise it will not be easier to understand, my lord. 23A, kindly see. 23A. 23, yes.
Is there any 23A?
No, that's why I just looking through it. This is mixed up with online, SSC online copy. I'll just correct this. This is, my lord, will kindly see.
Because SSC
33.1. My lordship will please, I'm so sorry, my lord.
33?
33.1. Conclusion. 33.1. At lordship got to 33.1. Operative conclusion, 33.1.
Yes, yes.
Once a complaint under section 44(1)(b) of PMLA is filed, it will be governed by section 200 to 205 CRPC, as none of the said provision are inconsistent with any of the provision of the PMLA.
Yes.
Now, my lord, will now turn to this judgment. So my lord, answer is there, that your answer has put it whether they can file an application, ex parte, or whether a notice has to be given. My lord, will kindly now see paragraph 30. Paragraph 30.
30 of Tarsem.
Tarsem, 30. Para 30, page 87 of Tarsem law. Para 30.
Yes.
Once cognizance is taken of the offence punishable under section 4 of PMLA, the learned special court is seized of the matter. After the cognizance is taken, ED and other authorities named in section 19 cannot exercise the power of arrest of the accused shown in the complaint. The reason is that accused shown in the complaint are under the jurisdiction of the special court dealing with the complaint. Therefore, after cognizance of the complaint under section 44(1)(b) of PMLA is taken by the court, ED and other authorities named in section 19 are powerless to arrest an accused, namely the complaint. Hence, in such a case, an apprehension of ED will arrest such an accused by exercising power under section 19 can never exist. So once it is seized, it goes before the court. The ED, you don't have any power to arrest under section 19.
But they can always go to the special court.
Special court files an application, give a notice to me, then situation will be different. Now, my lord, this your lordship doesn't have to go so much of details in this case. If necessary, we'll go later. But it is what summon procedure case. Your lordship has asked, this is what has been laid down by the Supreme Court in Tarsem. It is summon procedure case. Right. Now we go back to note. Now second judgment, kindly see note.
Yes.
Page 4, my lord. Of the note.
Page 4.
Yes, of the note.
Yes.
Kindly see. Accused.
Bhaskar Industries.
Yes.
Yes.
Accused entitled to be represented by engaged advocate. Now kindly see para 16.
Yes.
See the Bhaskar, my lord.
Yes.
If you see at paragraph 16, my lord.
So you are relying 16 and 17.
16, 17, 18, 19.
18, 19.
Yes. I'll just read it from the judgment, my lord. 16.
Yes.
Section 251 is the commencing provision in chapter 22 of the code which deals with trial of summon case by the magistrate. Lordship got it? If enjoins on the court to ask the accused whether he pleads guilty when the accused appears or is brought before the magistrate, the appearance envisaged therein can either be personal attendance of the accused or through his advocate. This can be.
But it says 25 section 251 is commencing provision of so and so.
Yes.
Trial court of summons cases by magistrates.
Yes. Yeah, because summon procedure, my lord, is a summon case from 200 to 205. What are the procedure that is in summon case normally? It enjoins.
But summon cases by magistrate, but this is not a magistrate.
No, but special court. But the court in terms of said that it is followed. Summon case has to be followed. So this special court also exercises an act of magistrate, my lord. Like the my lord, PC Act, special judge. He acts like a magistrate only, my lord. So it enjoins on the court to ask the accused whether he pleads guilty when the accused appears or is brought before a magistrate. The appearance envisaged therein can either be personal attendance of the accused or through his advocate. This can be understood from section 2051 of the code, which says that 2051, whenever a magistrate issues a summon, he may, if he sees reasons so to do so, dispense with the personal attendance of the accused and permit him to appear by his pleader. Thus, in appropriate cases, the magistrate can allow an accused to make even the first appearance to a counsel. Magistrate is empowered to record the plea of the accused even when his counsel makes such a plea on behalf of the accused in a case where the personal appearance of the accused is dispensed with. Section 317 of the court has to be viewed in the above perspective, as it empowers the court to dispense with the personal attendance of the accused, provided he is represented by the counsel in that case, even for proceeding with further steps in the case. However, one precaution which the court should take in such a situation is that the said benefit need be granted only to an accused who gives an undertaking to the satisfaction of the court. He would not dispute his identity as the particular accused in this case, and that a counsel on his behalf would be present in the court, and that he has no objection in taking evidence in his absence. The precaution and necessity of further progress of the proceeding, including examination of the witnesses. Paragraph 18. A question could legitimately be asked, what might happen if the counsel engaged by the accused, whose personal appearance is dispensed with, does not appear, or that the counsel does not cooperate in the proceeding with that case? We may point out that the legislature has taken care of such eventuality. Section 205(2) says, magistrate can in his discretion direct the personal attendance of the accused at any stage of the proceeding. The last limb of section 317(1) confers a discretion on the magistrate to direct the personal attendance of the accused at any subsequent stage of the proceeding. He can ever resort to other steps for enforcing such attendance. Now, last paragraph. The position therefore boils down to this: it is within the powers of a magistrate and in a judicial discretion to dispense with the personal appearance of an accused, either throughout or any particular stage of such proceeding in a summoned case. If the magistrate finds that the insistence on his personal appearance would itself inflict enormous sufferings or tribulence on him, and the comparative advantage would be less, such discretion need to be exercised only in rare instances where, due to the far distance at which the accused resides or carries on business, or on an account of any physical other good reasons, the magistrate feels the dispensing with the personal attendance of the accused would only be in the interest of justice. However, the magistrate who grants such benefit to the accused must take the precaution enumerated above as a matter of course. We may reiterate that when an accused makes an application to a magistrate through his duly authorized counsel praying for affording the benefit of his personal presence, being dispensed with, the magistrate can consider all aspect and pass appropriate order thereon before proceeding further. So these are the procedure which has been laid
And
down.
this procedure as per Tarsem law is applicable in the
200,
case of PMLA
205?
also.
Yes, correct. That's the position of law. If you see the next case, my lord,
Yes.
TG is 2011, 2 SCC page 772.
Okay.
2011, 2 SCC page 772.
It's on the same point, right?
Same point. Paragraph 7, your lordship can note down.
Yes.
7, 8, my 9.
7, 8, 9.
9 is reiterated, Bhaskar Industry has been reiterated, and paragraph 10. Paragraph 10.
Yes.
Now another judgment, because on the same line,
Same
I will
line,
not
yes.
trouble your
Correct.
lordship.
Correct.
Punit Dalmia versus Central Bureau of Investigation, 2020, 12 SCC page 695.
Para 7, 8 and
Para 7, 8,
para 7 and 8.
8, 8.1, 8.2 and 8.3. Punit and Sharif we have given to your lordship. Lordship got it?
Yes, Punit Dalmia.
Punit Dalmia. And Sharif Ahmed is 2014 SCC online SC 726. Sharif Ahmed and another was state of UP. So these are the points on. Sharif Ahmed is very small paragraph 47, kindly see.
47.
One paragraph, my lord.
Yes.
Lordship got it 47?
Yes.
Just one paragraph.
Yes.
Further, the observation, kindly see the note, my lord. Note itself.
Note is there. No? Yeah,
Further, the observation that there is no provision for granting exemption from personal appearance prior to obtaining bail is not correct, as the power to grant exemption from personal appearance on the court should not be read in a restrictive manner as applicable only after the accused has been granted bail. This court in Menaka Sanjay Gandhi versus Rani Jethmalani held the power to grant exemption from personal appearance should be exercised liberally when facts and circumstances request such exemption. Section 205 states the magistrate exercising his discretion may dispense with personal attendance of accused while issuing summons, and allow them to appear through the pleader. With the provision of the code are considered to be exhaustive, cases arises where the court is silent and the court has to make such order as the end of justice require. In such cases, the criminal court must act on principle. Every procedure which is just and fair is understood as permissible till it is shown to be expressly or impliedly prohibited by law.
Correct.
Now, my lord will kindly see the next point. Tarsemlal. Now, the paragraph will be different, my lord. Tarsemlal. Non-bailable warrants should not be issued as a matter of routine. Point C, my lord. Point C.
Tarsemlal case has been given.
Yes. Now, I have given 33.5. 33.5 kindly see, Tarsemlal.
Yes, but there was some this thing.
No, that is, I have your lordship corrected.
Correct.
Now, your lordship will now, third point, my lord. This is a third point. Non-bailable warrant should not be issued as a matter of routine,
So
my
you
lord.
are relying on paragraph 33.5.
33.5. Yes.
33.5. Yes.
My lord, just read, we'll read para 33.5. If the accused does not appear after summons is served or does not appear or on a subsequent date, special court will be well within his power to issue a warrant in terms of section 70 of CRPC. Initially, the special court should issue a bailable warrant. If it is not possible to effect service of bailable warrant, then a recourse can be taken to issue a non-bailable warrant. Here, my lord, someone represented by lawyer Amit Singh was representing throughout. So, the procedure which has been laid down
Should have been a
bailable, then non-bailable warrant of arrest.
Yes.
Now, my lord will kindly see. Now, this is what. Now, see another judgment, Inder Mohan Goswami, 2007 12 SCC pay 1. This is note your lordship will find.
Yes.
Para 53, my lord. 53, 54, your lordship will kindly mark. 53, 54 and 55. 53, 54, I'll just give that. 53, 54, 55, 56, 57 and 58. Your lordship can...
Yes, you can read out from here.
Yes. Yes, just read the note, madam. It needs little emphasis that since the execution, sorry, madam. I'm just sorry, madam. Non-bailable warrant should be issued to bring a person to court when summons or bailable warrant should be unlikely to have the desired result. This could be when it is reasonable to believe that a person would not voluntarily appear in court, or the police authority are unable to find the person to serve him with a summons, or it is considered person could harm someone if not placed into custody immediately. 54. As far as possible, if the court is of opinion that summons will suffice in getting the appearance of the accused in the court, summons or the bailable warrant should be preferred. The warrant, either bailable or non-bailable, should never be issued without proper scrutiny of facts and complete application of mind due to extremely serious consequences and ramifications which ensure on issue of warrant. The court must very carefully examine whether a criminal complaint or FIR has not been filed with an oblique motive. In a paragraph 55, in complaint cases, at the first instance, the court should direct serving of the summons along with copy of the complaint. If the accused seems to be avoiding the summons, the court in the second instance should issue bailable warrant. In the third instance, when the court is fully satisfied the accused is avoiding the court proceeding intentionally, the process of issue of the non-bailable warrant should be resorted to. Personal liberty is paramount, therefore we caution courts at the first and second instance to refrain from using non-bailable warrants. The para 56, the power being discretionary must be exercised judicially with extreme care and caution. The court should properly balance both personal liberty and societal interests before issuing warrant. There cannot be any straitjacket formula for issuance of warrant, but as a general rule, unless an accused is charged with the offence of commission or offense of a heinous crime, fear that is likely to temper or destroy the evidence or likely to evade the process of law, issuance of non-bail warrant should be avoided. The court should try to maintain proper balance between individual liberty, interest of public and state while issuing non-bailable warrant. On considering of the totality of the facts and circumstances of the case, impugned judgment order of the High Court cannot be sustained. Now, another judgment, 2012, 9 SCC page 791. It's paragraph, my lord, 10.
Yes.
Paragraph 10. 9. It needs, paragraph 10, my lord, it needs that little emphasized that since the execution, paragraph 10 of the judgment, of a non-bailable warrant directly involves curtailment of liberty of a person, warrant of arrest cannot be issued mechanically, but also recording satisfaction that in the facts and circumstances of the case is warranted. The courts have to be extra cautious and careful by directing issuance of non-bailable warrant, else a wrongful detention would amount to denial of constitutional mandate envisaged in Article 21 of the Constitution of India. At the same time, there is no gainsaying that the welfare of an individual must yield to that of community. Therefore, in order to maintain the rule of law and to keep the society in functional harmony, it is necessary to strike a balance between individual right, liberty and privileges on the other hand and the state on the other. Indeed, it is a complex exercise. As Kardak J. puts it, on the one side is the social need that crime shall be suppressed, on the other the social need that law shall not be flouted by the insolence of office. There are dangers in any choice as observed by Sohens. Now these are the points, my lord, when the non-bailable warrant should not be issued as a matter of routine, my lord. Now another point we have taken, Lordship will kindly see point D. An order once recalled become non-est and cannot be given effect subsequently, and it invalidates the entire proceeding. Now, my lord, have seen the orders of 13/12/2024, which has been recalled by way of 5/9/2024. Now, once it is recalled and it has to be reheard, so whether, my lord, by virtue of that order, which has been recalled and restored to file, it will be reheard. Then what happens to the position on 2/7/2024, which an order has been passed? My respectful submission, in view of the judgment that has been passed by the apex court, that becomes an invalidated order, my lord. Because what happens normally in a court, my lordship knows, that's why I said that whenever a step is taken by a complainant to issue a summon or a warrant, fresh steps has to be taken. Now it is executed through a respective police station. They go and serve the copy. Now suppose that person is not being found. Report will be given and it will be furnished to the court.
So that they reissue it.
Then there has to be reissuance of a fresh order. The learned court cannot say that what was there earlier
should
that
be executed.
That doesn't remain. It become a nullity, is a non become a functus official so far as that order is concerned.
Since you have already recalled that.
Recalled that and restored to file.
So
then IA 230 of 2024 will be reheard. This is what the apex court said in view of the judgment laid down. My lord, this is 1999, 4 SCC page 396.
Yes.
My lord, just I will read this, my lord. No need of going through the.
Yes,
it becomes more easy because I made a note of it.
Yes,
which have supplied the copy to my learned friend, my lord, other side. My
Other side has been
he
given.
has already served. Already served.
Copies.
He has all served. Copy served. My lord will kindly see para 6, my lord. I'll just not. It is 1 o'clock. My lord, it is 1 o'clock, my lord. I think your lordship will go for lunch.
16-page note has been served, nothing else has been served in the morning, only 16-page.
I have served the copy to the other side.
Can you send me a soft copy, please, if you don't mind?
That notes, Mr. Ramchandran? The notes you're talking about?
I have served a copy to my learned friend, but my learned friend suggested that he wants a copy, soft copy. We'll do that, soft copy.
Yes, Your Lordship.
He sent across to him.
Yes, I've already sent a soft copy. Yes.
We'll
I've
supply,
already
don't
sent.
worry. We'll supply. Already served, he can send it. So, my 2 o'clock, my.
Yes.
May I please, Lordship?
May I please, Your Worship? Your Worship, there's one item number 13 in the orders, Your Worship.
Team number 13.
Yes, Your Worship.
No one is there.
Both the councils.
No. This
Oh.
13. Yeah, what is your prayer?
Your Worship, I have to take, the service report upon respondent number 2 is not trackable. So I may be allowed.
You mentioned it too because of, the steno is not there.
My lord, before your lordship rise, my learned friend Raju Ramchan is there.
Yeah.
Because he was not there. 3 of this, what is the number? Item number 3. Read petition 26
Yes.
of 2025, which we have filed question.
That you want to put it for tomorrow.
Yes, tomorrow. If it's not inconvenient to my learned friend. That's a complaint case. Question, because there are views
Then my turn may come tomorrow, my lords, at any particular after 2:30 tomorrow. I'll argue all the matters in one go.
That is a different matter.
Yes, but let him complete this matter. So I'll argue all at one go at 2:30 tomorrow, my lords.
Okay, my lord. Tomorrow the matter has been, your lordship will fix it tomorrow.
No, what about this matter?
No, this matter I'll argue it. I'll argue this matter.
This matter you are arguing, Mr. Ramachandran?
This he may argue, but I will make my replies tomorrow, my lord, at 2:30 in this matter also.
Because tomorrow again the other matters.
No, what I will do, my lord, this
There
is
is
not.
one more matter of his, my lords.
There are one more matter. So my learned friend is saying that 2:30 he will give a reply if I am not
Give a
wrong.
reply to all the matters.
All these matters he'll give a reply. I will finish it off by tomorrow itself. This matter and the next matter. I'll finish this today itself. This matter.
And Mr. Ramachandran is going to do it tomorrow. Is it so?
Yes, my lords. I will, after he completes, I'll make the arguments, or I will begin the arguments of this matter, then he may start with the arguments of the other matter.
Correct.
Whichever is convenient.
What I'll do it for easy of the course, but 3 has got a connection with 1. So I'll do my argument. Then my learned friend can finish it off by doing both the matters together, if it is not inconvenient to him, my lord.
Yes, I will do both tomorrow at 2:30.
Yes, 2:30.
Tomorrow I'll do both the matters.
My lord, after 2 o'clock, your lordship again comes back. We'll continue.
There's a fourth matter where pleadings are to be completed.
We'll continue this, my lord.
So we'll continue with this.
With this, yes.
But Mr. Ramachandran is going to argue the matter tomorrow. only.
Tomorrow, give a reply, yes.
Tomorrow heavy. I have about 12 matters tomorrow in the Supreme Court tomorrow, my lord. I should be free by 2:30. In case of some difficulty, I'll ask for some time. Otherwise, tomorrow or day after, I'll finish it off. I don't want these matters to
It's okay, no problem, my lord. Let me finish it off my part, my lord.
Let's see.
The steno is here, Your Worship.
There's one more matter pending where the pleadings are not complete.
Which one? Which item?
It's not listed today.
Which one?
There's one matter which is not listed today. The pleadings are not complete.
Oh, that case, I think 33, no? 33 of 2024.
Yes, therefore.
No, it would have been good if you could have finished it off today only. This
No,
matter.
I'll finish
This
it off.
matter, yeah.
No, I'll finish.
No, I'm just
No,
talking about-
what my friend Raju is saying, let me complete my case because it will take some time. 3 and another matter.
No, that can be done tomorrow.
No,
but
that's why I'll finish it off my matter.
Then about this matter, his arguments.
No, what I am saying, my lord, I will complete my case 3. Then another matter is a 1, which I can do it tomorrow also, no problem. Let me complete my case
But
3
this
of-
case can be finished off today, correct?
yes, yes.
And like I'm just, curious whether Mr. Ramachandran is going to be argued this matter today or not, or he is going to argue it tomorrow.
No, he is going to argue tomorrow what he said, if I am not wrong.
I will argue tomorrow, my lords. 2:30.
Okay.
And there's one matter which is not tagged. That may also be tagged, my lords. Where pleadings are not completed. That's not listed.
Which is the item number? Okay, which is
It's not listed.
number?
Criminal petition 33 of 2025. Is not being listed because pleadings are not been completed. Because these are 2 main issues, my lord.
But
If
that
this
is connected to this.
My lord, yes, my lord, if these matters are over, then everything will go, my lord. 3 and 1, my lord.
Okay, we'll see it.
Yes.
That has got a stay in our application, which is made pursuant to Tarsim for production. So there he doesn't want to conduct that matter. It has to be, all matters have to be conducted simultaneously.
No, it has not been listed, and what can I do? It is
Therefore, I'm
not
requesting that
listed.
it be listed.
It will not be listed.
Okay, we'll pass an order at, we'll see at 2 o'clock. We'll
Yes.
see at 2 o'clock and pass an order if required.
Grateful.
Yes, deeply obvious.
want me to 6 weeks? No, 6. Substitute notice will be given. Assam yes. Office not there. Consignment is not tracking. Section was track one. Will not track one. Update was up for what's there? I think we are excited about the lesson to around the time.
May it please your Lordship. Lordship, I would like to mention from the admission item number 8, 10, 11, Lordship. Let this matter be listed after 3 weeks, Lordship. Consensus, Lordship. It's a joint prayer.
1 second. On the joint prayer, item numbers
8, 10, 11, Lordship.
8, 11, 10, 11. On the joint prayer made by the councils appearing for the parties, let the matter be fixed after
3 weeks, Lordship.
3 weeks.
Obliged, Lordship.
All the matters, huh?
May I please, Your Worship? Your Worship, I'd like to mention item number 13 in the orders, Your Worship. Here, Your Worship, the notice upon respondent number 2 is not traceable. So I may be allowed substitute notice upon respondent number 2 by way of paper publication.
Mr. So-and-so appearing for the petitioner.
Applicant
Appellant submits that service on respondent, service on all respondents.
respondent number 2, Your Worship.
Service on respondent number 2 is yet to be completed, and the same is not traceable.
Not traceable.
Not traceable. He prays for allowing him to take fresh steps of notice. Prayer is allowed. Let the service of notice, fresh service of notice, be taken on respondent number 2 by a speed post.
Paper publication, Your Worship. Paper publication. Substitute notice by way of paper publication.
Does the mode you try?
Oh, it's not. It's from outside the state, Your Worship, so it may be difficult for the company to send the person.
He is allowed to take steps for service of notice by way of paper publication. In
One local daily in the state of
one
Assam.
local and one national daily.
Okay.
One local daily newspaper published in Assam.
Assam.
And a national daily newspaper. Let the matter be fixed after 3 weeks.
6 weeks, Your Worship.
Why 6 weeks?
Because it's from Assam, Your Worship.
Publication only,
Some process.
4 weeks, after 4 weeks.
Lordship, I'm for the respondent 1.
Yeah, Mr. So-and-so appears for the respondent number 1.
Returnable date.
Respondent number 2 is who?
The driver, Your Worship.
Yeah, MSc appeal.
Owner of the vehicle.
MSc?
Yes, Your Worship.
Okay. This one.
Obliged, Lordship.
Returnable date may be fixed, Your Worship, after 4 weeks.
After 4 weeks.
Okay,
Lordship.
okay, Your Worship. Much obliged.
Yes,
My lord, I'll just try to finish it off.
yes.
3 and connect it with 1, because that's has got relevancy with another case, that's item number 7.
Yes.
It has got relevancy, it will become easier. If this case, your lordship hears this case, it become very easier next case is concerned. That's why I want to do it together.
Correct. And what about the other matter?
My
they
lord,
have been
other
talking about?
matter, the learned, my friend Mr. Raju said that he will do at 2:30. So, my lord, what I propose, subject to your lordship convenience, because your lordship is stuck with our only matter, there are few other matters. So, in the morning half, if your lordship can take other matters and fix our matter at 2 o'clock, so that becomes, so other lawyer also get a chance, my lord.
But whether we'll be able to finish it by tomorrow? If
No,
if we
I
fix
will,
it?
I will try. No, I will try today itself. And my part, if we start at 2:30, I will try to finish it up 2:30 itself. He will start at 2:30 onwards. Then he will try to, he said that I will finish it off his matter. 2 to 3 hours, because there is a connection with these with 3 along with 1. That's why I'm saying it will not take much time, my lord. 3 with 1. So now if we finish it off, then maybe, I don't know, thereafter, tomorrow, if we finish it off, maybe 1 or 2 hours I need a reply. Maybe not me tomorrow, maybe online also I'll see I can give a reply to his particular argument which is that. Because there is no question, again he is giving a reply, my lord.
No,
So at least 3 and 1, your lordship will finish it off these 2 matter. 3 and 1, which have got a connection. And so far as my learned friend is concerned, so let it be fixed at 2 o'clock, my lord.
the other matter.
Other matter, 1, let it
Item
be at
number
2
1.
o'clock. Item number 1. Okay. Now I will come and meet here. Tomorrow, 2 o'clock. Because 2 o'clock, because if your lordship fixing up, so I'll come late from Dimapur, I have to come.
Okay. So we'll fix all the matters at 2 o'clock.
Oh, yes, correct, my lord, right. Okay?
To 2 o'clock tomorrow.
No problem.
At 2 o'clock, all the matters will be fixed.
Yes. 3 also will be
So
fixed.
item number 1, item number 1.
And
I
item
have
number,
passed some order to be fixed tomorrow. So, but time hasn't been mentioned, so you can mention at 2 o'clock.
item number 3 also, my lord. 3, no, which was? 1 and 3. 3.
1 and 3.
Yes, 1 and 3, yes, 2 o'clock.
So 3 also it will take some time.
2 at 2 o'clock. This may not. 3 will, because I will just tell your lordship, we may file a reply, we will tell. I will not trouble 3 tomorrow.
And what about the production matter Mr. Raju was mentioning?
That if this is being heard, that becomes easier for the court. That's
so,
I
so
can.
we'll have to fix that matter tomorrow. That matter
Yeah.
also tomorrow.
No, because there is no affidavit has been filed, nothing has been filed. Your lordship can list that matter, there is no problem. Listing is no
Because it's a
problem.
link matter. Let's
Yes,
see.
yes, list it. my lord.
That I'll pass an order.
Yes, yes.
It will be fixed tomorrow. Item number this thing, registration numbers.
Number, yes. That a criminal petition number 33, 33 or 30? 33 of 2020. Criminal petition number 33 of 2025.
Just write it down, I'll pass the order.
Before break, I cited the judgment which was not before the court. This copy. Copy was, I read, my lord. This copy was not there.
Correct.
These copies were not there. Now, my lord, may I start, my lord?
Yes.
My lord, if your lordship now takes my note at D,
Yes. Yes.
An order once recalled becomes non-est and cannot be given effect subsequently as invalidates the entire proceeding.
Yes.
I think this is the root of the case. Now, factually, your Lordship knows the case. Now, 1810 also, your Lordship knows what was the outcome of 1810.
Yes.
5/9/2024. 5/9 to where it was recalled?
Recalled.
Restored to file. When it restored to file, my lord, next date was fixed on 1810.
Yes.
1810, my lord, the lawyer represented, it was exempted.
Exempted.
Correct, my lord? And the interim order continues.
Yes.
So this was the position.
Yes.
And it continued. 1312 order has been passed. In this case, 3, which has been put to challenge because the learned trial court said that the order of 5/9/2024 has been violated. Now, your Lordship has looked into it. Where is the question of violation of the order of the court? Because 3 direction pass. One is restore to file, recall. Second is non-value warrant of arrest is recall is kept in abeyance, and 4th is to appear in the next date, that is 1810. And then next date 1810 he should be present. 1810, my lord, exempted. This is the position.
Yes.
And no further order were passed for personal appearance of the accused. Your Lordship see the order sheet. No order has been passed. Your Lordship is clear on that point.
Yes.
Now, more than that, this is a major point which I found. And I am thankful to my learned friend who has showed me in the morning and said this will be the main point. The root of the case so far as the legal issue is concerned. We may have, subject to what my learned friend argues it, that no, factually you are incorrect. That's a different thing altogether. But law is very clear on this point. What is that point, my lord? This point, which, my lord, is that if an order, my lord, just your lordship, if an order is recalled, now 2 things has to be looked into it. 2 things. One is that whether the power of recalling is there in a criminal court or not. If you see 362 of the CRPC, what is the power given? If a lordship looks into CRPC, kindly see the CRPC. CRPC, not we into CRPC, madam. See 362 of the CRPC for a moment. I think, my lord, statutes is important to understand.
Yes.
Then the law will come later on. See 362, my.
Yes.
Court not to alter judgment, save as otherwise provided by this court, but or by any other law for time being in force, no court where it has signed a judgment or final order disposing of a case shall after or review the same except to correct or a clerical or arithmetical error. So these 2 conditions has been given. You cannot alter it except for correcting a clerical or arithmetical error under 362. My lord, this scope, how it is developed in the Supreme Court in a recent judgment and in criminal case, also in criminal case, but how it evolves from civil to tribunal and thereafter it goes to a criminal court. So this I want to show it. And why I am showing it? Because our case, which I will connect it, there was an order which was recalled on 5/9/2024. 5/9/2024. Now, 13/12/2024, the learned judge, what he does, an order which has been restored to file, which has been recalled, which was kept in abeyance, is the power of that judge, of the judge who passed an order on 13/12, can he revive the order? Which order, my lord? 2/7/2024, when non-bailable warrant was to be executed. Initial order. He revives that. Non-bailable warrant of arrest which is executed, he revives. He passes an order on 2/7/2025, open-ended non-bailable warrant to be executed.
Or an IA.
In IA 230 of 2024.
So IA was disposed of.
It was IA was pending. IA 230 of 2024 on the very first day, without giving any notice, he disposed of that IA. Now, we came up before this court for recalling of the order on 5/9/2024. 5/9/2024, it was heard, And this order of 2/7/2024, IA 230 of 2024 was recalled. Recalled, restored to file. And the court said, you have to be recalling of the order and it is to be reheard. That means 230 has to be heard. In the meantime, non-bail warrant, which was executed, that has been kept in abeyance. Subsequently, on 13/12/2024, the learned special judge, what he does, he said that no, there is a violation of the order of 5/9/2024. There is I will tell you, Lordship, there is a story behind why he passes the order. 5/9/2024, he says on 30, there is a violation of the court's order. Which order? 5/9/2024. Your Lordship reads the order.
Yes.
About 5 times I have read the order. Your Lordship has to find that where is the violation of the order. With great respect, I will say there is no violation of that order. There cannot be any violation of the order. Number two, which is most important, which I am connecting with all the judgment, is the power is vested to that particular special judge itself to interfere or to recall or to revive the order of 2/7/2024. Again, the non-bail warrant to be executed. I think he cannot. Because that he becomes powerless, that order itself is invalidated. He cannot pass that order. This will be our argument. So any order which has been recalled by the court, it becomes a non-est. You cannot revive that order which has been recalled. Any further proceeding thereafter, out of a non-est order, it becomes bad in law. Could I make your Lordship understand my
I'm
law?
clear.
It becomes honest in the eye of law.
So that cannot be executed later on.
Yes.
I mean, like reviving that.
Yes.
So
Now, how this
now a fresh
matter?
order has to be
Now,
passed.
how the Supreme Court has dealt, where the court has to look into it, procedural side, and one is substantive. Substantive law and procedural law. My Lord, I will like to draw your Lordship attention to first judgment.
But like 362,
Yes.
362 talks about
A bar.
Huh?
This is a bar.
That
There cannot be any alteration of a judgment or any order.
judgment or final order.
Final order.
Whether it's a judgment or final order.
No, this is all criminal orders will be a judgment in final or a final order. My Lord, I have not. My Lord. Suppose an order is passed by a criminal court. Now, what we do
In
it?
a criminal court for
Now, suppose if it is an ex parte order, then there may be power to recall that order. If it is not an ex parte order, if it is an inter party order, then it is only you are agreed, that becomes a final order.
Is it you
My Lord, I will tell your Lordship in this way. A main case is pending, out of an offshoot is there.
Correct.
By filing some application.
Correct.
Let us see in some case you file an application for examination of witnesses. Examination, recalling again that same witness. It will be outcome, it is offshoot of that major case, main case.
Correct.
Now that order has been passed. So that becomes a final order. After hearing the pass, after order is being passed by the court, it is only open to challenge it. So there is no question of alteration of that order. What your Lordship means that no, whether it is a final order, judgment, your Lordship understand.
See, then what I need to understand is that, this is an application for issuance of non-bailable warrant.
Yes.
And that application was basically heard ex parte.
Yes.
Ex parte, after hearing the ex parte, then a non-bailable warrant was issued. And that petition was, that application was disposed of.
Yes.
So thereby you mean to say that that is a final order
Yes.
in respect to that IA,
Yes.
and that therefore that this will be termed as final order disposing of a case.
Yes.
Is it a
Yes.
disposing of a case?
Yes. But how Supreme Court has interpreted 362, I will show that, my Lord.
That will have to look.
I will. See, my Lord, this is an extra we are showing it. But on the face of it, first 3 points is well covered.
No, that is fine.
My Lord, one, Extra I am showing it because it's very important point which I felt. That also law can be laid down in view of the Supreme Court judgment. And it has a connection with this next case, one, FEO, declaring me as, I'll tell your Lordship, first point with Tarsem Lal was very clear, saying that whenever you file an application, you have to give notice to the other side. Other side has to be heard, thereafter an appropriate order can be passed. In this case, 2/7/2024 off date they filed it and an ex parte order was passed. So they have violated Tarsem Lal because by the time, in the meantime, a complaint case was filed, cognizance was taken, summons were issued, the lawyers represented the accused. Thereafter, when the proceeding proceeded, my lord, then 2/7/2024 that application was filed.
In that case, I mean, once the order is passed, it's a final order. As per your submission, this is a final order, correct?
So if that
if that is a final order,
then
whether the power of recalling is there or not.
Yeah, that's what I want to show it. That I want to show it. The power of recalling is there.
Power of recalling for what purpose? Power
Yes,
of recalling also for purpose of
when it can be recalled.
Yes.
This is, my lord, I will show this court, my lord. I will just show the judgment. Then your lordship will be clear on this point. They discussed when it can be called, when it may be recalled. Kindly see first judgment.
So if 362 is applicable to your case, then
No, 362, when it can be recalled. This is why I am showing 362, the power given to a criminal court. What is 362? You cannot alter a judgment or a final order unless there is a arithmetical or clerical
so
mistake.
in that circumstance,
Yes,
whether
this
it
is
can be
one.
recalled.
No, this is what the Supreme Court.
If it doesn't
no,
have
it has the power. That's why 2025 it discussed that in what circumstances, even 362, how it can be recalled. This I will show it. First, kindly see the judgment
Yes.
of 1999
For SCC.
for SCC, page 396.
Yes.
Please take the judgment, my lord. Paragraph 6, my lord.
Yes, paragraph 6.
See the judgment, paragraph 6.
Yes.
What is the power to recall? Inherent power to recall its own order vesting in tribunal court was noticed in Indian Bank. All or courts, my lord will kindly mark or courts, S, courts, was noticed in Indian Bank versus Satyam Fibers, India, by paragraph 23. The court has held that courts have inherent power to recall and set aside an order. 3 grounds, my lord, kindly see 3 points. Obtained by fraud practice upon the court. This is not the case in our hand, not the case, my lord. 2, when the court is misled by a party, no. 3, kindly see, my lord. When the court itself commits a mistake with prejudice a party, is this ground number 3 falls in our case. When the court itself commits a mistake which prejudices a party. With prejudice
What was
a
the
party.
mistake committed by the court?
That is a mistake with Tarsem Lal. A notice should have been given. Notice should have been given. Ex parte order. Principle of natural justice to be followed.
Correct, but like in your case, the recalling order was passed on what ground?
This is not recalling. This is not recalling. What I am saying, the parameters which particular recalling can be passed by
No,
the
that
court.
is, why it's not recalling? It says that inherent power to recall its own order.
Yes.
So now it says that when the court itself commits a
That's what I'm
mistake.
saying, right.
Yeah. So it's a recalling.
Yeah, that's
so
why.
Now, what was the ground of recalling in your case?
My count.
Only ground was probably that it was an ex parte.
Ex parte order.
Ex parte order.
It was not heard.
So whether that can be termed as a mistake?
Yes, kindly see a 3 further in AR Antule versus so and so. Court has noticed mentioned set aside judgment being permitted where a judgment was entered in ignorance of fact that this is not applicable. 3, kindly see Roman 3. A party has had no notice, and a decree was made against him, and such party approached the court for setting aside a decision ex devisio justitio on proof of the fact that there was no service. So I am covered by number 3, and Satyam Fiber deals with 3, my lord. Satyam Fiber deal with, my covered is 3, Roman 3. And in AR Antule also, my lord, further explains 1 and 3, my lord. 1, kindly see, a judgment was rendered in ignorance of the fact.
The 3 is clear, 3 is clear.
Yes, yes.
But this.
Not been served.
Septum Fibers case 3, when the
Yes,
court
3. And further, AR Antule also discuss, kindly see Roman 1. A judgment was rendered in ignorance of fact that a necessary party has not been served at all and was shown as served or in ignorance of the fact that necessary party had died. Here, my lord, there is no sir, it is no sir. So I think Roman 3 is covered. A party has had no notice and a decree was made against him, and such party approached the court for setting as a decision ex devisio justice on proof there was no service. Now, if Lordship kindly see para 8 now. Para 8.
Para 8. Yes.
In our opinion, a tribunal or a court may recall an order earlier made by it if, number 1, the proceeding culminated in order suffer from the inherent lack of jurisdiction. Such lack jurisdiction is patent, no, not our case. There exists fraud or not is our case. 3, kindly see. There has been a mistake of the court prejudicing a party. So I am prejudiced by the order that has been passed ex parte, my lord. And mistake which the court has done it because court has not gone through Tarsem Lal judgment. And they have to follow the principle of natural justice, which has not been done. 4, my lord, a judgment was rendered in ignorance of the fact that was a necessary party has not been served at all or had died and the estate was not represented. I think so. So this particular has been reiterated in Budhia case, my lord. Budhia has reiterated in this case, my lord. What AR Antule and also Indian Bank by Saitan Fibers. They developed and their opinion, my lord. Budhia's opinion is paragraph 8. I think this is one judgment, my lord.
Yes, yes.
Another judgment. I think this is most important. 2005, 13 SCC page 777.
2005, 13 SCC, yes.
Kapra Mazdoor, my lord, Ekta Union. Now, if you see para 18, my lord.
Para 18.
Para 18. But this is, I think, most important judgment, which is followed in 2025 also. This point was, so your lordship will kindly, this point, 2025, while deciding in a criminal case. Yes, it was, my lord, it was therefore submitted before us, relying upon Greenlist Bank Limited versus Central Government Industrial Tribunal. Even in absence of an express power of a review, tribunal had the power to review its order if some illegality was pointed out. The submission must be rejected as misconceived. The submission does not take notice of the difference between a procedural review and a review on merit. This is important, my lord.
So your case is procedural review?
Yes, right. Correct, my lord. This court in Greenless Bank versus Central Government Industrial Tribunal clearly highlighted this distinction when it observed. Now kindly see. Furthermore, different consideration arise on review. The expression review is used in the two distinct senses, namely 1, a procedural review which is either inherent or implied in a court or tribunal to set aside a palpably erroneous order passed under a misapprehension by it, and number 2, a review on merits when the error sought to be corrected is one of law and is apparent on the face of record. It is in the later sense that the court in Patel Narsi Thakresi case held that no review lies on merit unless a statute specifically provides for it. Obviously, when a review is sought due to procedural defect, the inadvertent error committed by tribunal must be corrected ex devisio justitio to prevent the abuse of its process, and such power inheres in every court or tribunal. I think this is what this judgment is said, procedural and one is on review on merits. And see 19 is very clear, 19. Applying this principle, it is apparent when that where a court or quasi-judicial authority have jurisdiction to adjudicate on merit proceeds to do so, a judgment on order can be reviewed on merit only if the court or quasi-judicial authority is vested with power of review by express provision or by necessary implication. The procedural review belongs to a different category. Now you please mark this, my lord. The procedural review belongs to a different category. Please mark this, my lord. Procedural review belongs to a different category. In such a review, the court or quasi-judicial authority having jurisdiction to adjudicate proceeds to do so, but in doing so ascertains whether it has committed a procedural illegality which goes to the root of the matter and invalidates the proceeding itself. This is now, see, 13/12/2024, my lord. That's the to be executed. That is execution, my lord. Executed, my lord. Now, so what it does, it invalidates the that proceeding itself. The execution also.
So if that goes, hypothetically, if that goes, then your declaration of under the fugitive fact, this will also go.
Yes,
that's
what I am showing it. One of the ground, there is another ground. Other ground, that is what I am showing it, my lord. Because then, pausing for, I'll again go through it. Why? Again on 18, I'll show the date. 24/10/2024, they filed an application IA 791 of 2024, declaring me as a fugitive economic offender on the ground of pending warrant is pending. Warrant is pending. On 24/10/2024.
Which is already been recalled.
Yes. Prior to 13/12/2024. My lord, forget about 13/12, prior to 13/12. So when you file an application, IA 791 of 2024, prior to 13/12/2024, on 24/10/2024, that a warrant is pending, there is no warrant pending at that relevant time. That warrant on 5/9/2024 was recalled and was kept in abeyance. So where is the question? A warrant pending and you file an application declaring me as a fugitive offender in the next case. That is what we have challenged. That is why I am showing the judgment, my lord. Now, my lord, proceeding itself and invalidates the proceeding itself and consequently the order passed therein, cases where a decision is rendered by the court or quasi-judicial authority without notice to the opposite party or under a mistaken impression, notice has been served upon the opposite party where a matter is taken up for hearing and the decision on a date other than, very interesting, other than the date fixed for hearing, that means no date, are some illustrative cases in which the power or procedural review may be invoked. Same in our case, my lord. In such a case, the party seeking review or recall the order does not have to substantiate the ground that the order passed suffers from an error apparent on the face of record or any other ground which may justify a review. Nothing on merit, it is only on procedural side because there is an error apparent on the procedural side because you could not have, because now kindly see what the Supreme Court said. Either off date, ex parte, off date, they doesn't know of the hearing also of that case. So, yes, now my lord will kindly, he has to establish, very important, he has to establish that the procedure followed by the court or the quasi-judicial authority suffered from such illegality and that it vitiated the proceeding and invalidated the order made therein inasmuch as the opposite party concerned was not heard for no fault of his or that the matter was heard and decided on a date other than the one fixed for hearing of the matter which he could not attend for no fault of his. In such a case, therefore, the matter has to be reheard in accordance with law, exactly what the learned trial court has followed. For with law, without going into merit of the order pass is liable to be recalled and reviewed, not because it is found to be erroneous, but because it was passed in a proceeding which was itself vitiated by an error or procedure or mistake which went to the root of the matter and invalidated the entire proceeding. My lord, entire proceeding means execution also. This is what I am saying, my lord. It was held that once it is established respondents were prevented from appearing at the hearing due to sufficient cause, it followed that the matter must be reheard and decided again. So, I think, my lord, this judgment is very clear.
Yes.
Now, this judgment, my lord, now we are going into how in criminal cases. Now, this is, my lord, decided in 2025, is a latest judgment.
Okay.
SCC online SC 1783. This is the fifth point. My lord will kindly see there's a fifth point. Now you will kindly see now the point your lordship will kindly see.
Which case was this?
Now your lordship
Vikram
will
Bakshi?
take my note. Vikram Bakshi, kindly take my note.
Yes.
E, my lord.
Yes.
Page, my lord, 14.
No, I got it. Vikram Bakshi, you have given the case?
Yes, I have given. Three judgment together we have given.
Yes.
My lord will kindly see, an order of recall under procedural review cannot be indirectly reviewed by a substantive order. This is our fifth point, my lord.
An order of recall under procedural review cannot be indirectly revived by
A substantive order. Substantive order 1312. Substantive order 1312. 1312.
Yes.
Now please see the judgment of the Supreme Court Vikram Bakshi, 2025 SCC online SC 1783. Please see para 31. Now we are, your lordship was asking about criminal courts. Now we are on criminal courts now.
Yes.
See para 31. Because this judgment has discussed about other laws also.
The Greenledge has been discussed.
Precedents, but we are not troubling your lordship with other judgments. Because they discuss everything here, my lord. See para 31. This court, however, in exceptional cases, has carved out limited scope for exercise of review powered by criminal courts. Please mark criminal courts. In Greenleaf Bank Limited, your lordship, which I have shown,
Yes.
it was observed review can be distinguished from procedural review and a substantive review. A procedural review is inherent or implied in court to set aside a palpably erroneous order passed under misapprehension by it. However, a substantive review is when error sought to be corrected is one of law and is apparent on the face of record. It is in the latter sense, this court held that no review lies on merit unless specific provide under statute. So normally your lordship knows, when he come to the court said, what on merit? These are all merit. We cannot review. This is on law. If you are agreed by judgment or offer judgment, go before higher court. But procedural, then yes, of course.
Yes.
Now see para 32. This distinction has been further clarified in Budhia, which I have shown, my lord.
Yes.
Wherein this court, now my lord will kindly see, wherein this court has laid down certain grounds on which a criminal court can review or recall each other. Now your lordship question has been answered now. Your lordship anxiety was that, which a criminal court can review or recall a judgment or order, that is, when the proceeding before itself suffers from inherent lack of jurisdiction or a fraud is played upon court to obtain the order, or a mistake of court causing prejudice to the party, or the order was in ignorance of non-serving of the necessary party, or party has died and estate was not represented. It was further clarified that this exception were subjected to any limitation, that such grounds cannot be raised to recall or review if they were available during the original election and none was not availed. See, we were absent, my lord. That is true, my lord. Your lordship has seen. Because 27
Because
2000
it was fixed on an off date.
off date and it was heard. An ex parte order was passed. Apparently on the face of record. 33. In Ganesh Patel, this court held that application for review, seeking procedural review and not substantive review. That application for recall, my lord, kindly say, sorry, man, it is that the application for recall seeking procedural review and not substantive review to which section 362, now your lordship was asking that, of CRPC can be attracted is permissible. This court upheld the order of the High Court wherein it recalled the earlier order passed in the absence of respondent and based on false information. So now, my lord, your question has been answered by the Supreme Court in this case. 34. A careful consideration of the statutory provision and the aforesaid decision of this court clarify the now well-settled position of jurisprudence of section 362 of CRPC, which when summarized would be that a criminal court, as envisaged under CRPC, are barred from altering or reviewing their own judgment except for the exception which are explicitly provided by the statute, namely correction of a clerical or an arithmetical error that might have been committed, or the said power is provided under any law, other law, for the time being in force. As a court become functus officio is the very moment a judgment or an order is signed, the bar of section 362 CRPC becomes applicable. This, despite the power provided under section 482 CRPC, which this veil cannot allow the court to step beyond or circumvent the explicit bar. It also stands clarified that it is only in situation wherein an application recall of an order or judgment seeking a procedural review that the bar would not apply, and not a substantive review where the bar as contained in 362 is attracted. So we have very clarified that it is not procedural review you can recall, but substantive review on merit you cannot recall. Then, my lord, then bar of 362 will come. Otherwise, that bar of 362
So, bar of 362 doesn't apply to your case?
No, it will not apply. That is why the order has been recalled.
No, that was...
But recalling of the order, restoring to the file, that he cannot execute that again.
That was my specific query, in fact.
Kapra must do, my lord. Then goes, my lord.
No, that is why I was asking 362, whether 360 is applicable to your case.
Yes.
Because 362 is not applicable to your case.
Yes. So, my lord, ultimately, para 34A, I think after the judgment was dictated, they wrote, with great respect to learned judges, these were Chief Justice, I think 34A has been inserted. After all, my lord, judgment was done before pronouncement 34A, otherwise 34A would not come.
They clarified it.
Anyway. And having said that the following exceptional circumstances may be identified, wherein a criminal court is empowered to alter or review its own judgment, or a final order under section 362 CRP. A. Such power is expressly conferred upon court by CRPC or any other law for time being in force. B. Court passing a judgment order lack inherent or see, my lord, the court passing such an judgment or order lack inherent jurisdiction to do so. C. A fraud or collusion is being played on court to obtain such judgment or order. Or D. A mistake on the part of court caused prejudice to a party, this is our case, or fact relating to non-serving of necessary party or death leading to estate being so not brought to a notice of the court while passing the judgment, such judgment or order. It needs to be reiterated all these exceptions are only accessible for seeking a recall or review an order of judgment if a ground that is raised was not available or existent at the time of original proceeding before the court. Mere fact that the said ground, although available, was not raised or praised during the concerned proceeding, does not provide for an exemption to party to assert it as a ground. Now, this is what the Supreme Court, I think, dealt with. So it makes very clear, my lord. 362, there are cases where, my lord, if there is a procedural review can be done substantive review cannot be done. Recalling can be done. On the face of it, our case is that apart from other facts, we have got facts. Legally we are speaking, that here a order has been recalled.
That is in procedural lapse, so review can be done because it was not passed on merit.
Yes, it is on the procedural side.
Correct.
You have not served notice to the other side.
So
you
that-
should
that
have
is-
served a notice to the other
so
side.
that's-
It's a blatant violation of principle of
So
natural
that's why
justice.
362 CRPC is not applicable.
Not applicable, but
Bar is
these
not
are-
applicable.
bar is not there because this being a procedural
lapse.
Yes, lapse. So all the time I was saying before the court, today itself it can be allowed. Let it go, because why unnecessary to keep pending here? 260, 230 will be taken up by the court.
That's why I wanted to hear him today only, so that I could have in fact decided the matter today. Now, otherwise again all these things will
my
be
lord,
clubbed together.
what is difficulty with us? That is why, my lord, with great respect, I was arguing the matter. Even then, few matters are there in the High Court. I thought I will finish it off, because I'll say, let them say whatever they want to say. All the time we have been harassed with some other this way or that way petition. All the time you have, Lordship has seen, we came to the court. Nobody comes for an enjoyment before a court, because some action has been taken. They violated the court's order. They filed some application. So we want these matters to be settled. End of the matter, my lord. Then we know where we
So
stand.
if this
They
matter
know.
is decided, then the other matter can be decided.
That becomes easier. That's why I want to do it. Connect. I want to connect it. That's why when I argued this matter initially, and I said there is a live connection with 3 along with this 1.
But 2 will be different. I mean, that other one will be different.
Different. That is different. All will be different.
PML
Yes.
will be different.
Yes. So, my lord, now, note kindly see, my lord, now, see the conclusion, I made a note. Conclusion submission, my lord. See at page 16, my lord.
Yes.
1. The order dated 2/7/2024 was passed in absence of petitioner without affording an opportunity of hearing on 2/7/2024. The said order was rightly recalled on 5/9/2024 in IA number 531 of 2024. My lord, 1. You have also got it?
Yes, yes.
Concluding submission.
Yes, I've got it.
Keeping the non-bailable warrant issued early in abeyance and restoring IA 230 up to for rehearing. Number 2, upon recall, the order dated 2/7/2024 become non-est in law as if it never existed. As such, any further proceedings such as execution of non-bailable warrant issued earlier pursuant to order dated 2/7/2024 is bad in law and is liable to be set aside in quest. Moreover, further direction passed by order dated 13/12/2024 to execute the earlier non-bailable warrant amounts to substantive review of the order dated 5/9/2024 passed in the same proceeding. The said direction is also in conflict with the order dated 5/9/2024, wherein the learned trial court has directed for rehearing of the IA number 230 of 2024. Further, the said order dated 13/12/2024 was passed by overlooking the order dated 18/10/2024 and 12/12/2024, wherein the learned trial court had adjourned the hearing on IA number 230 of 2024. As such, the entire proceeding culminating out of an order dated 2/7/2024 becomes a nullity, including the order dated 13/12/2024, whereby the learned trial court has directed to execute the non-bailable warrant which was issued by the order dated 2/7/2024. Moreover, the said order was passed without taking into account the order dated 18/10/2024, whereby the personal appearance of the petitioner was dispensed with on 18/10/2024, and no further direction for personal appearance was passed on 18/10/2024, 24/10/2024, or 12/12/2024. Further, no objection was raised by prosecution on 18/10/2024, wherein the personal appearance of the petitioner was dispensed with. 4. The learned trial court proceeded with a closed mind in a mechanical manner to direct that earlier non-bailable warrant issued earlier to be executed. As such, on the premises aforesaid, petitioner most humbly prays before his honorable court, instant criminal revision may be allowed by this court for range of justice. So I thought that my learned friend request that make a note so it become easier to the court.
Yes, it will be
We
definitely.
served in, and I connected with the dates. That's why I have shown. So this is our case so far as 3 is concerned. They filed, my lord, affidavits in this case.
Correct.
Now affidavit, some their paragraph, a paragraph admit going through this as it. We'll show their affidavit. But they normally ED, we say affidavit in opposition, thereafter a reply, they say affidavit in reply. When a petition is filed, they said affidavit in reply.
Okay, they have said, yes.
Affidavit in reply.
Affidavit in reply.
Now,
It was filed on 22nd April, that one,
yes.
right?
My lord, see content para 22, see para 9 of our petition, my lord. Take para 9 of our petition, 1 and my lord. 9 and 10 we have placed, my lord. See my criminal petition, my lord.
Yes, 1 second.
See criminal petition, my criminal petition. And one hand keep the affidavit in reply, my lord.
Para 9.
Para 9, I have shown, my lord.
Yes.
See my para 9. Once I will read, my lord, then I'll connect to their affidavit. In the intergram, the respondent filed an application being IA number 230 of 2024, inter praying for issuance of an open-ended, non-bail warrant of arrest against the petitioner. Learned trial court did not serve any notice whatsoever of the purported application of the petitioner or his advocate. Petitioner do not have any knowledge, notice whatsoever of said application or date of the hearing. What is the reply? See para 22. Contents of para 9 are wrong and what you got it?
Yes, misleading, yes.
The misleading, the learned special judge, vice order dated 5/9/2024, has directed the application respondent department be reheard and also directed the respondent department a copy of application IA number 230/2024 be supplied to the petitioner through his counsel. A copy of application was served on the date of hearing on 18/10/2012. And what reply they are making it? 1810, my lord, they doesn't make any averment to this day. They should make an honest statement that yes, we did not serve. Where is that you made it? Our contention that no notice has been served, no copy. Where is your averment there? Where you denying? You are saying are wrong and misleading.
Yes.
So, my lord, this is vague denial, my lord. They doesn't say anything about that. On fact, that on 2/7/2024, we have filed application for issuing an open-ended non-bail warrant. We have issued a notice to you. Please appear. And it is an update. How can I know, my lord? 2/7/2024 is an update. And what reply they are saying? See, my lord, kindly. They are talking about 5/9. What about 2/7? You did not say any. Our whole case is based on 2/7. You are talking of 5/9, which was recalled. You are talking of 18/10/2024, when the copy was served to me.
Yeah, then that paragraph 10 reply, what is it?
Yes, 10. That in reply, can I read this? On 2/7/2024, para 10, the learned trial court proceeded hear the IA of number 230 of 2020 ex parte and reserved the same for order. On the very same day, that is 2/7/2024, learned trial court with a closed mind and in the most mechanical manner allowed the said applicant issued an open-ended non-bail warrant of arrest against the petitioner herein. Petitioner crave leaves to refer and hear. Now see it at 23. Their reply, my lord.
Yes.
See their reply. Then in reply to contents of para 10, it is humbly submitted that the contents are misleading. That learned trial court on 12/7/2024 appreciating not 12/7, it is 2/7, my lord.
Yes.
Where is 12/7? 2/7, it will be 2/7. After appreciating all relevant facts as well as contention produced before it, passed the order of issuance of open-ended non-bailable warrant of arrest against the accused. It is further submitted at para 9. The learned special judge has directed the applicant respondent department be reheard on 1810, while it is order dated 5/9/2024. As the petitioner has contested the claim, copy of the application was not served to his application and also directed the petitioner present in person. However, the petitioner failed to appear onto the directive of the Honorable Court, thereby clearly exhibiting intention to delay the trial. Hence, by the order dated 13/12/2024, Learned Special Justice PMLA held a non-bailable warrant issued by this court, which was kept in abeyance through earlier order be executed. But my lord will kindly see para 10. It does not deal with any of this statement which we made. Contention doesn't deal. Something they are saying, something else. My lord, they doesn't say that 2/7/2024 was not an ex parte. It was an inter party. We served a notice. You did not appear. Where is that? And secondly, my lord, they
It
have
doesn't
not.
talk about the recall.
I'm sorry.
It doesn't talk about the recall also.
Yes, right. So these are doctrine of non-traverse, my lord. This will be doctrine of non-traverse. You have admitted. That means
The
you have,
most important thing was, as far as this court is concerned, what I could understand till now, the recall thing. The recall, they haven't dealt with.
yes. Recall del Kursan.
It does not say that the recall is They never challenged 5-8. No, they are
But
only
because,
saying
my lord-
saying that keeping it abeyance and like now re-execute it.
But-
They are avoiding to say this or what? That's what I understand.
5/9/2024, if you are aggrieved by recalling order, they could have challenged that order. They have not challenged that order. They accepted the order. What they want to say, you have violated. What I violated? My personal appearance, that is not a violation. My personal appearance is a direction passed by the court. Non-bailable warrant is an interim order which was kept in abeyance. When the court said you have to appear on the next date, that doesn't mean that is a violation of the court's order.
Correct.
Well, I think, my lord, we have gone to it, and I have given a reply. To
Where was the recall order?
recall order is 5/9/2020,
5/9, yes, sir.
5/9, and that is your lordship will find in page.
Page 30 something, 31.
Recalling order is, my lord, this 5/9/2024 at page 63.
Page 63, yes.
Page 63. See page 63. This is 5/9/2024.
It does not record that I was hurt.
Where, my lord, kindly see, it was an ex parte order. This is 5/9/2024 is saying, and citing all the judgment of Tarsemlal. And kindly see the operative portion of the case, my lord. Finding of the court at page 66, kindly see. In the instant case, kindly see, my lord, in the instant case, at page 66.
Yes.
In the accused petitioner was not arrested during the course of investigation, absconding, evading arrest as claimed, but he was not on a but. Be it as admitted, the ED can still seek custody even though the accused was never arrested after hearing the accused person. As noted above, kindly see, as noted above, the application for ED praying for open-ended non-bail warrant of arrest was heard without affording an opportunity of the accused. As such, I am of the opinion applicant ED praying for open-ended non-bail warrant be heard and given opportunity of hearing. So this is a finding of the, you did not challenge. Same court, my lord. You did not challenge this order. This is a final order. And subsequent on 13/12, he again saying that has to be executed. Well, if you are aggrieved by this order, my lord, we are aggrieved by 13/12. We have come to the court now.
Yes.
We have come to the, where is that? They have challenged this order of 5/9. They have not challenged that order. Excellent. So I think this is our case, my lord.
So basically, what you are saying is that the rehearing means recalling. That specific word of recalling is not mentioned.
No, sir.
Where?
Where? In the order? 5/9 is a recalling.
In the operative portion, it says keeping it abeyance.
No. You kindly see, recalled and reheard. One second. My lord, will kindly see.
No, recall is not there, probably, Mr. Das. See, there are two things.
But recall, otherwise he cannot restore it. If it is not recalled, it cannot be restored, my lord. Kindly see. IA 230 was disposed of, my lord. IA 230 was disposed of.
So by implication, what you are saying is that by implication.
My lord, if you see at page 63, kindly see page 63 at number 2, 02, this application under so and so filed by the accused, praying for recalling,
or
cancelling the order,
that I have seen,
non-bail warrant. Now, when you pass the order, my lord, when you restored, if you see this, reheard on the next date, returnability which is fixed on 18th.
So by implication, you are saying that like once it is reheard, so that means
it should
like
be
you have
reheard,
recalled.
recall that order.
So you'll have to recall it.
Recall,
So,
and non-bailable warrant has been kept in abeyance, my lord. That order saying non-bailable warrant to be executed, this has been kept in abeyance.
No, that is the reason they have not used the word recall.
Because why? 27 has been disposed of. I'm sorry.
No, Mr. Das, what, why they have not mentioned this word recall in their affidavit is that recall hasn't been used here. So that's why they are using the word, probably that is the reason. That's why
But
they are
if you
keeping
see
it at abeyance and all.
If you see at page 62
Page
of
62.
a criminal petition,
Yes.
see page 62,
Yes.
where IA 230 was disposed of, see page 6204.
04.
According in view of the aforesaid reasons stated above, instant application is allowed. An open-ended non-bailable warrant of arrest is hereby issued against the accused so and so with the above observed direction. Instant IA stands allowed and disposed of accordingly. So it is disposed of accordingly.
Yes, yes.
So whenever I have to file an application, when there's a procedural review has to be done, recalling is only way of by filing an IA, which has been done by filing IA 531 of 2024.
No, that I have understood. But like the contention, what they have made in their reply is that this non-bailable warrant was not recalled. It was kept in abeyance.
I know.
Therefore, that can be executed. That can be executed by an order. That's what their contention
that's what
is.
I'm saying. No, my lord, 2024, that order was recalled by order dated 5/9/2024. 27/2000 disposed of by issuing a non-bailable warrant to be executed. 5/9/2024 that was recalled. Which was recalled? Order recalled on the order which was passed on 2/7/2024.
So order was recalled.
Yes, by which warrant was executed?
But
on
not the
2/7.
NVW.
No, entire order was recalled where non-bailable warrant is to be executed. Non-bailable warrant to be executed. That was entire order was recalled. Entire order was recalled, number one, saying that there are three directions which was passed. One is that we'll restore, we'll rehearse.
So once in the IA,
I will clarify, my lord, this is important. Your lordship wanted to know. Yeah, I have to clarify this because they will raise this also. My lord, they filed an application on 2/7/2024 for open-ended issuance of open-ended non-bailable warrant.
Yes.
Right. Now, apparently, on the face of it, it was an off-date. 2/7/2024.
There is no dispute about that.
No dispute.
They have not raised the
Great.
data. They have not raised that issue also.
That it was on not an off date. Number three, the fact is that it was no notice was served because no off date.
So nobody.
We are not aware of it.
Correct.
No notice has been given.
Correct.
So on 2/7/2024 itself, an order was passed by the court.
NBW was
Issued. To be issued, right, Mel? Now 2/7/2024, that's because they want a non-bailable warrant to be issued.
Correct.
So that is the whole crust of the entire issue.
That is the IA.
That is an IA. Now on 5/9/2024, an application from our side was filed for recalling / cancelling of the order of 2/7/2024 order.
For whereby the NBW was issued.
Now both the parties were heard. ED was also heard, and ultimately a judgment was passed on 5/9/2024.
So the crux is that. So
Yes.
5/9 you see, 5/9 the operative order.
Yes.
Page 66.
Yes.
Page 66 is what was the order passed. See, they have not recalled the court has not recalled this thing, NBW. What they have done, that like, we'll keep it in abeyance. We'll keep this NBW in abeyance and we'll rehear this matter.
Correct. No, that's what no, they recalled the order for non-bail warrant to be executed. That was kept in abeyance. But that IA of 2030, 2024 still remains to be decided by the court. 2024 was recalled. Am I able to understand? Because your lordship will not say, I am not saying that IA 230 has become infructuous.
No,
it is not the case.
No, not.
I am saying 27/2024 was the order whereby the issuance of non-bailable warrant issued by in pursuance to orders court, that was kept in abeyance by the court in a subsequent order 5/9/2024.
Yes.
5/9.
That was kept in abeyance.
Kept in abeyance. But after hearing it, now suppose today your lordship finds it number one in the ex parte, no notice was given. Correctly, it is they could not have passed that order. Subsequently on 13/12/2024, whereby non-bail warrant again to be executed. It cannot be made open. Because in view of that, there is no violation of the court's order of 5/9/2024. Ultimately, what the order can be passed? I am asking myself. It's simple that this is not that this order goes. The order of 13/12/2024 goes because there is no violation of the court's order which is passed on 5/9/2024. And what is there? We will send it back to the learned trial court to decide the issue of 230 or 2024. Apparently there is an order of the court. It should be reheard. The matter should be reheard. Now it will be kept open to the learned trial court to decide the issue. Again, because that was in total an ex parte order. Again to be heard. Their application which they have filed for issuing an open-ended non-bailable warrant of arrest, that again will be heard by the learned trial court.
No, that I understood.
Yes.
What I am.
But my argument before this court, legally I am saying, legally arguing also, that the order which was passed by the learned trial court on 13/12/2024, to the extent that there is a violation, again, the power which he passes on the ground, then again the non-bailable warrant, again it has to be executed because violation of the court's order. So in view of all the judgments which I have placed before the court, that he doesn't have that also. He doesn't have that power also because in view of the judgment of the Supreme Court.
Yes.
$230, my lord. $230, my lord will kindly say, $230 was disposed of.
230 was disposed of, but it was
But
it was disposed of.
But it was revived again
No,
by the court.
It was revived again, correct?
Yes.
But see, there are two things. One is the application, and other is the NBW.
Yes.
Now, by this order, this court has ordered that NBW should be kept in abeyance till the next returnable date.
Yes.
Next returnable date means what? That the date the court is going to hear that application. Correct?
1810.
So it has been kept in abeyance.
Yes.
So in that circumstances, what this court wants to know from you, in that circumstance, once the NBW is kept in abeyance, whether a fresh NBW has to be issued or that's the same can be executed.
No. No. The IA 230 of 2024 has to be heard.
It has to be heard.
It has to be heard. So, no, that's why I'm saying, my lord. Your lordship, that's what we argued. No, what the court is saying, that he could not have passed an order based on that 2/7/2020. He could not have revived that order by way of 13/12/2024. Your lordship is right.
Yes.
That what he could have done he could have simply said, oh, no order to be passed. One, because there is already direction passed by the court 5/9/2024.
Correct.
That particular application has to be heard, 230 to be heard, and we'll decide. Then thereafter we can make an argument 230, whether it can be based on the order of reviving that 2/7/2024 or a fresh non-bailable warrant to be issued. That is the domain of the learned trial court. Am I right? That's the domain of the learned trial court.
No, because why this court is asking you is about that since you have been submitting that once that order is gone and it is to be reheard, so that NBW has gone and fresh NBW has to be issued.
No, that is will be on the basis of an argument to be advanced before the learned trial court. I am showing some judgment. On the face of it, your lordship is examining the validity of the order of 13/12/2024. Your lordship is examining 3 of 2025.
Absolutely.
Now, my argument will be of twofold. One is that once the order of 5/9/2024, why we say the words, it has not been mentioned recall, automatically is recalling an order of 27/2024. Otherwise, he could not have said restore to the file, and secondly,
So
he
it's
could
by-
not have said an non-value warrant will be kept in abeyance. It's like recalling that order.
Correct, sir, but by implication,
By implication is recalling of an order.
Recalling of the order.
And restore, my lord will kindly see, will be reheard. Reheard means recalling of that order of 27.
So without recalling it, he could not have reheard it.
Yes.
He could not have reheard it.
What, my lord, any proceeding thereafter, after 27/2024 is bad in law, will become honest. Any proceeding thereafter. But warrant originate from where? 27/2024 only. 27/2024. Now thereafter, after 27/2024.
So without rehearing you, I mean, nothing could have been done.
Yes.
So that, but in the instant case, without hearing you,
Yes.
I mean, they have again passed this.
Then Kapra Mazdur case, my lord. Entire proceeding will go. Entire proceeding. Entire proceeding will go. It is bad in law.
Once it is recalled.
Yes.
So that
Entire
is why-
proceeding goes. My lord, in so many words, the word recall is not there.
That's what
I know, recall maybe not, but our application was there.
By implication,
But
you are
when it
agreeing
is
by-
reheard and the warrant of
Restored.
arrest has been
Once
kept
it
in
is,
abeyance.
when the case is restored
Restored.
back,
Yes.
and it is to be reheard, by implication you are recalling it.
Yes.
That is your argument.
Yes, that is
and
my
like, why I have asked this is like because they are not, they have avoided using this word.
No, they have
recall.
avoided, they have not mentioned anything
Because-
that whether,
But in that case, that case law, that Kapra Mazdur case,
yes,
whether that will be applicable or not, they will, I mean, that can be an argument.
yes,
So that is why probably, I mean,
yes. So this is my case in 3 of 2025 is concerned, my lord.
Yes.
This is my case.
Yes.
Now immediately, yes, no, ठीक है, sir. So immediately, move my lord, move down. One second. Now immediately I'll show, my lord, 1.
so in the affidavit, other than this, you don't want to show anything.
Yes.
In their affidavit? And there is an additional affidavit also.
Yes, I'm sorry.
There is an additional affidavit in this matter. So what is that?
Oh, additional affidavit is what? My lord, that is disposed of. My lord, what has happened when this 3 of 2025 was pending before this court? They filed an application. I think IA they have filed. IA 13 of 13, if you lordship I am not incorrect, 13 of 2025 I think.
This is, no, this is an additional affidavit filed by you.
Yes.
Bringing on record.
Subsequent, my lord, subsequent development that has taken place.
Okay, so this is not required.
Subsequent development that has taken place in 3. If your lordship dispose of this matter, then subsequently your lordship doesn't have to mention
Nothing
it.
important to be shown.
Yes, yes.
Nothing
My lord, I'll just tell your lordship that 3 of 2025 may not be relevant to see this particular in judgment, right judgment. 3 of 2025 when we move this matter. Now what has happened, my lord? They filed an application before this court in connection of 3 of 2025. IA. I'll show. Then 13 of 2025, they filed an IA before this court in connection with 3 of 2025.
For?
Now, there were two prayers which has been made. One prayer is that in view of that section 19, there will be no embargo to the ED to arrest under section 19. And there is an urgency in this matter, so the matter should be heard. There is urgency in the matter, it should be heard. We filed an objection, then detailed hearing has taken place, and their application was rejected by this court. And on the ground, court said, why will pass that order? Whether there is an embargo, whether doesn't embargo, it is up to you. If you feel that section 19 to be invoked, you invoke it. You don't have to take permission from the court. Why they wanted? They wanted to get a clarification of the order from the court because
Assembly will say something else.
There were some few orders under section 50 originally where at the time of investigation, they said these are the dates where we didn't cooperate with the investigation of the case. And they also say after we got some interim protection from the court, that challenging that complaint, challenging that ECIR, then also court passed an order that no coercive measure, but you should cooperate with the investigating agency. So all this we have violated. So
they came for.
They want a clarification from the court's order that this is a man who is evading, he is not cooperating with the. So please, you clarify that there will be no embargo under section 19. Then we showed Tarsimla. Now where is the question? Because once it is under the cognizance has taken place, complaint has been filed by before the court, then it is the power of the court. It is not that you become the powerless under section 19. Yes, you can do it, but you have to file an application before the court, serving notice to the other side. They will give a reply, and thereafter your order can be passed. That is why court rejected. After that rejection also, my lord, they file application before the court before the learned special court for production warrant, so that my custody interrogation can be there. Another application they filed before the learned trial court. Then, my lord, this matter we call for recalling, that was on an off date. Ultimately, that culminated to challenging the order before this court. That is, my lord, criminal petition 30 of 2025. The additional Solicitor General also heard. In detail, affidavit was filed. After hearing it, that order was set aside. That you cannot do it. Because there is already an order protected by this court. Non-bailable warrant not to be executed. That has been 13/12/2024 has been stayed by this court.
Yes.
So now, thereafter also again they filed an application which is coming tomorrow before this court. That is criminal petition 33 of 2025. Again they said section 19 should be invoked. Now when the matter was moved before this court, we said again they have come up. This is a barred by adjudicator. Once the court decides we are protected, they cannot file this type of application once after another application. This is what they are trying to do.
And the other matter that which has not been listed today, I mean, their pleadings will be required to be completed, or like or this.
I think that pleading is required, according to me. Which matter?
That matter which is not being listed today.
No, tomorrow it will be listed.
Tomorrow it will be listed.
No, it is not. Pleading is not completed.
So pleadings will be required for that.
Yes.
In that matter to be disposed of.
Yes.
Or all these can be disposed of together.
Without that particular is separate. Pleading has to be there.
That is against the production this thing only.
Yes, production warrant. Pleading is not been completed. Not production. For arrest under section 19. Okay. Production or for purpose of section 19.
Malord, if I may take the liberty, that is in fact the case where we move the learned special court in terms of Tarsimlal, asking for permission of the court to take his custody. Because Tarsimlal says, Malord, if a complaint stands filed, your power to directly arrest a person takes a back seat. You have to then take judicial permission. So it is that application that we moved, which my learned friend challenged and has now apparently got a stay on it.
But when earlier, when we fought this case, earlier round of litigation, they denied. They said Tarsimlal is not applicable in your case. Today my learned friend is saying Tarsimlal is applicable. Because section 19, there is an order passed. So Tarsimlal is not applicable in our case.
So now,
that's what they said earlier.
Now, on the basis of the Tarsim Lal only, they have gone to the special court
Yes.
and they have sought for custody.
Yes.
Sought
Yes.
for custody
Yes.
and that you have approached this court.
We approach this court,
And this court has stated that.
state that, and we'll argue on this matter when time comes, my lord.
Whereas my learned friend's case throughout has been that Tarsim Lal should be followed. Despite
Yes.
that, my learned friend comes and says that he is prejudiced and gets a stay.
No, we will disclose our defense when time comes. When time comes, we will disclose our defense. So we are concentrating on, my lord, 3 is gone.
So was there any necessity for like listing the matter tomorrow with this case?
My learned friend wants to be listed.
My lord may list it because it will give a good complete picture of the, even assuming, my lords, that case, even assuming pleadings are not complete.
That will be on a different footing altogether, I think.
But it gives a flavor of, my lord, the differing stand taken by the party in different proceedings relating to the very same case. So my lord may list it. How to deal with it, my lord may decide tomorrow.
Okay.
My lord, we'll now please take up 1. It will be immediately, it has got a connection with 3.
Yes, 1 second.
So it's become easy. So what 3 I have completed, my lord.
Yes.
3. Now please take criminal appeal 1. I have not made any list of dates or books. Whenever it is prepared, I will give it to the other side also. My lord,
So I'll have to again open up tomorrow for argument of. Was this matter heard earlier? No.
no, yes, there is an interim order passed. Interim order passed.
No, not in the hearing.
No, hearing is not.
Yes.
Is a compilation with your lordship, this compilation, separately, not that. Another compilation, so far as 1 of 2025.
No, it is not there.
Maybe your lordship see that. Extra copy we have got, we can give it.
Is there any compilation given with this in this case?
My lord,
Some
I know,
spiral binding.
we have given when the matter.
1 second, let's see like whether it is. This is, yeah.
1, that is 3, that is 3, my lord.
1 second, let me see. No, it is not there.
We will give an extra copy. We will give an extra copy with us. Other side of Diasan, right? We have given to the other side earlier itself.
You have received this, right?
Earlier also, earlier itself when it was moved, long back.
So it's a compilation of the orders.
No, orders, these are orders. These are orders. To make it more easier, we have said, my lord. This is already made here, it is in the petition itself.
Yes,
but to make it easier, again, we have to go, that's why.
Yes.
It's not something we are showing which is not a part of the case, my lord.
Yes,
No,
this is only compilation of the order. That's what I'm saying. It's
Sometimes it
compilation of
becomes
the
easier.
orders. And
for
copy
the
has been
court.
given to you.
Yes.
The local council.
My lord, in this case, criminal appeal we are dealing 1 of 2025.
Yes.
Where on 22/1/2025 we have been declared as fugitive economic offender. On 22/1/2025. So my implication is that my property will be confiscated before trial, my lord. The property which has been attached by ED, my lord, that will be confiscated by them. So that is the, my lord, declaring me as a fugitive economic offender, that's the implication, my lord. Property which has been attached by them, my lord, they will confiscate.
But you have not appeared before the trial court once also, right?
No, they have not passed any order. My God, I was represented throughout by the lawyer. My application for exemption, hybrid are all pending before the court. Your lordship has seen that. Summon procedure case, my lord. That's why I have shown the judgment of the Supreme Court, my lord. And what is the stage? Supply of copies.
Yes,
Now see, my lord, 38, page 38.
page 38.
38. After 1810, my lord. Your lordship has gone to 1810.
Yes.
So that is why easy to connect here in this case, my lord. See page 38, my lord.
Yes,
See the order of 24/10/2024.
yes.
Lordship said it.
Yes.
CR put up along with IA 791. So, my lord, the application which they have filed under section 4, this is registered at IA number 791 of 2024, filed by the complainant, ED,
That a fugitive economic.
through the learned special PP declaring of the accused as fugitive economic offender and confiscation of the property under section 10 and 12 of the Fugitive Economic Act 2018. I have perused the application. According issue notice to all the, very lucky, my lord, a notice has been issued this time. Very lucky.
1810, 230 was fixed for rehearing.
1810, my lord,
There was some other.
my lord, your lordship knows the background of the case.
Yes.
1810, my lord, the case which 1810, that 230, that will be reheard 230.
Yes.
That never happened. Your lordship knows till today. So, in the meantime, on off date, they filed his application.
No, 1810 never happened because he came to this court, right?
They came, no, copy was not
copy was not,
supplied.
yes, correct.
Copy was not supplied
Copy
to
was
us.
not supplied, yes.
Now, my lord, why?
And in the same date, exemption order was passed.
Now, this 230 declaring me as a this application declaring me as a fugitive economic offender, two requirements are there. I'll show it. In this case, they filed this application. In the application, notice has been issued to us. Thereafter, we appeared before the court. And now I am telling you, lordship, first ground, IA 230 of 2024 was pending. What was that application, my lord?
That was for, yes.
That application was, my lord, open-ended non-bail warrant, IA 230, which was, order was passed on 2/7/2024.
That is yet to be heard.
5/9/2024, it was kept in abeyance.
So it is yet to be heard.
Knowing fully that no warrant is pending. 230 was fixed for rehearing, no warrant was pending. What was the necessity of the ED to file an application on 24/10/2024 on an off date, IA 791 of 2024? My lord, what is that? My lord, under section 4 you file it, procedure laid down under 10 and 12, I'll show it, 12 is the order to be passed.
No, is it those are additional prayers or like?
No, I will tell you, lord.
Do they need to file separate applications for that?
Yes.
Section 4 and
Yeah,
section
they have filed. My lord, kindly see, that is an FUO Act. First, my lord, I am reading this 24/10. Is to be shown before this court.
That order, okay.
To my court, good. Yeah, but dekhai dikile board tumi so. Itu side, itu hoy na. Ar kontu order? Itu. Yes.
You wanted to show us section?
Now you see section 2F. 2F. See section 2F. 2F.
2F is the definition.
Yes.
Yes.
See, my lord, fugitive economic offender means any individual against whom a warrant for arrest in relation to a scheduled offence has been issued by the court.
Schedule offence means?
Scheduled offence means under, my lord, the
CRPC?
Yeah, PMLA Act.
Is it only for PMLA Act?
No, it is for PMLA Act, 120B and 420 PMLA, and other section also.
No, this fugitive, the fugitive economic offences.
This is under
Act,
PMLA Act. This is a PMLA.
Is it only applicable to PML or PML offences or something else also?
PMLA. It is under PMLA, my lord.
Where does it say so?
Yes.
No, I don't think so.
What is that?
It's not only
Any
for
other
PML.
department?
It's
Any
not,
other?
It's not for purely
Any
for
other?
PML.
Any other?
And that's why I'm asking now,
Yes.
if it's for other these things also,
Any other?
other also, then what is this scheduled offence?
Yes.
Scheduled offence under this act or what?
Just.
Yes, it is. It should be under this act only.
This act only under
Yes,
PG?
yes, these are the offences.
Yes.
So do you fall under this?
Page 11. Page 11.
The place 11 is there, but which
Yes.
is the offence, scheduled
Page
offence that
11.
you have committed? 120B.
3 and 4.
120B only, probably, in your case.
But before that, kindly see 2F. 2F, kindly see 2F. First 2F, you kindly see.
1 second. PMLA.
Section
PMLA 3 and 4. Okay.
3 and 4.
So 3 and 4 is there, and section 120B is there, which is in the Kohima case.
Yes.
Kohima case.
Yes.
Correct?
Yes.
So these are the scheduled offences. So this is applicable to you. Yes.
Yes. And
Now-
schedule offence has been defined under 2M, my lord. 2M.
2M.
2M. Lordship got it? 2M.
Yes, it is. Means
Now,
offence
there
is scheduled.
are two things, my lord. If you see definition of 2F,
Yes.
that fugitive economic offender means an individual against whom a warrant for arrest in relation to a scheduled offence has been issued by any court in India who has left India so as to avoid criminal prosecution. Now, there are two things. That's why I have shown.
So you are in Dubai.
Now, my criminal prosecution was never avoided by any of the order that has been passed, because these are, my lord, under the summons procedure case. It has been represented by the lawyer. So there is no occasion that, my lord, to avoid prosecution, my lord. Am I right, my lord? To avoid prosecution. I may be abroad, but I did not avoid prosecution, but it was represented by my counsel.
Yeah, correct. This.
Represented by the counsel. It is after complaint is filed, not, my lord, investigation, my lord. After the complaint is being filed. That is why, my lord, avoid criminal prosecution. Lordship has seen that he has left India so as to avoid criminal prosecution after investigation when the complaint is filed, so that I avoid the criminal prosecution which they have lodged money laundering case 1 of 2024. And all the time, your Lordship has seen, my lawyer was I was represented by a lawyer. My application with VC also was pending, my lord. Now, why I want to show this 2F? 2F, I want to show a warrant for arrest has to be is pending. This is the first criteria, my lord.
But when this application was moved by the ED,
Then warrant was not, no warrant was pending.
at that time, warrant was kept in abeyance. So
Yes.
warrant was kept in abeyance and the matter was to be reheard.
Reheard.
So that means there is no valid warrant against you at that point
So
of time
if
because
there
it
is,
was in abeyance.
if there is no valid warrant, then could you have filed this application? IS 791. This is the first ground, my lord. One applicant and B is also.
So you are taking 3 grounds. One is warrant.
Yes.
Second is like you that has left India to avoid criminal. You have not, because you are representing the court
But
by
to a
engaging
lawyer.
a counsel.
And number 3,
And being abroad-
two also, being abroad refuses to return to India. I have returned back to India.
So you have no.
I have returned back to India. On that day I was not there. On that day application which was moved. Subsequently I have been returned back to India and I am custody of the ED in some other case. I have returned back to India and subsequently I am in Tihar jail for some other ED case. I am not no longer in Dubai. I came back. Because there is a background of this case, how I came back. There was some circular issued against me, red corner circular issued. Then we moved before the Punjab and Haryana High Court. Punjab and Haryana High Court has also granted an interim order that okay, we will stay in this, but within 2 months you have to come and approach, you have to participate with the investigating agency, which was done in the case.
So
I came within the...
At present, you were in custody,
custody of the ED. Yes, ED, under the custody of the ED. I am under the custody of ED. There is absolutely no problem. I am under the custody. Not in this case, some other case.
Correct.
So, yes, number one, my lord. These two, my lord will kindly see, being refused, suppose one is fulfilled, my lord, this has left India so as to avoid criminal prosecution.
The refusal
then,
to return it doesn't apply to your case because first they'll have to ask you to come. No?
Yeah.
They'll have to ask you that like, you come and appear before this
correct,
court.
correct, right.
And then you refused.
Yes.
Then only it will come.
That is different. So here number one, on the date when you moved this application 24/10/2024, there was no warrant pending. It was kept in abeyance by the court.
Right.
So your application which you have filed is a premature application. IA 791 of 2010 is a premature application. I do not fall under this definition. So I don't follow a definition of 2F because no warrant was pending. Now suppose tomorrow your lordship decides that no warrant was pending, it was kept in abeyance, then automatically, my lord, this also will fall down. In revision 3 is allowed for a moment, my lord.
Yes.
Then automatically this also, criminal appeal also, my declaring into economic offender is bad in law. Automatically will go.
Because no other ground they have taken for
now,
declaring you as
now
an economic
I will
fugitive.
argue, in addition to that, there are other grounds. Their application which they have filed under section 4, they file an application, I'll show that.
Yes.
There is, my lord, a procedure that has been laid down by legislature, that's section 10. That has to be mandatorily followed by the court. What are the procedure that has been laid down under section 10? Then only when you follow the procedure, then under section 10 we can pass an order. Here 12. Here is a case, 2F, I don't fall, your lordship has seen that. On the date when your application was filed, that is the premature application. Because on the day you also knew that my warrant of arrest has been kept in abeyance by the court. That means at that time no warrant is pending. So Kapra Mazdur, my lord. So 2F, my lord, 2F, my lord, no warrant is pending. This is one. Now secondly, this left India so as to avoid criminal, that also goes because I have been represented being a summon procedure case. Secondly, I am back to India. This is number 3. Number 4, which is most important, see now 4, section 4. Now see section 4, my lord.
No, now since you were, there is a query from the court. I mean, this person has the council and the council has also need to answer. Now, since he is in custody, whether this petition has become infructuous?
No, date of the order, it has not become on the date of the order.
No, presently.
But declaring me,
presently.
no, suppose your lordship says infructuous. No, then the problem will come, what they will do if this order is not set aside, because this order will remain.
No, what I am saying is that the application that they have filed before that special court, it itself becomes, doesn't have any value in that.
No, that they didn't have the value, they did not have the value on the day when they moved the matter.
No, I do not know about the particular date at that point of time. But as of now, since he is in custody, is there any need? Is there any need or necessity?
No, it's there. But I'll show it.
Only for confiscation.
2010, by hearing both the side or the party has been disposed of by the learned trial court, declaring me as a fugitive economic offender on 22/1/2025.
22/1/2025.
That 22/1.
But when you have been taken on custody?
I have been subsequently, long, no, it has no subsequent connection, that doesn't become invalidate this has become, doesn't become infructuous.
No, it doesn't become invalidate, but whether, I mean, they
My
have
lord,
to
leaving
answer
up,
this.
no, my lord, leaving, no, they will say that this has become infructuous. But my argument is it is not become infructuous. Because as on date, 22.
Infructuous means like their order also goes.
Their order has to go.
That's what I'm saying. See, now, they have filed this application with certain object, correct?
Yes.
Object and purpose. Purpose is that like he is not in India because they have filed this application under this section 2F, isn't it? Section 2F saying that like your warrant is there, saying that you have left India, saying that you are not refusing to come. Now since they're in, he himself is in custody.
No, my lord, I know. See, my lord, the trial court order, finality, it has it in finality on 22/1/2025, which is put to challenge. Unless they say that we don't want to press that order 22/1, then end of the matter.
No, that is what I'm saying now.
If they say that no, we will not press this application, then end of the matter. 22/1/2025.
That is why I want to ask them whether there is any need of that order,
No,
which has already been passed.
No, then your lordship will decide. Like saying that if they are not pressing that order, fine, that order automatically goes.
That's what I just wanted to understand.
That order will go. That order has to be set aside. That order has to be set aside.
No, that is why I'll have to ask them.
Yes.
That I'll have to seek for a reply because
Yes,
since
my
now
lord,
he is in custody.
My lord,
whether
my lord, please forget about that custody for a moment, my lord. With great respect, I am saying. Custody part, your lordship will leave apart. That your lordship will examine 2-3 issues. Leaving apart, as if like he's in Dubai. Let us say he's in Dubai. For a minute, my lord. He's in custody with the ED. First, your lordship will deal with whether on the day when the application was filed, whether warrant was pending or not. First, 24/10/2024, on that day, no warrant was pending. That warrant pending was kept in abeyance. What is the effect of keeping in abeyance? That also was argued before this court, and in prima facie interim order was passed. They say something else. Court has explained what is meaning by in keeping in abeyance. Also judgment. This is one. Forget, let us say that he is abroad. Number 2, my lord, which is most important, is that application filed by the ED under section 4. And there are certain procedure that has been laid down. Whether the court has followed that procedure. Because these are draconian law, my lord. You have to follow step by step the procedure which has been laid down. Only thereafter you can pass an order under section 12. My argument 1 will be that no warrant was pending on that date, so end of the matter. Addition to that, you could not have filed an application on that day. Now let us say, for an argument's sake, that there was a warrant which was pending. Let us, for an argument's sake, that there a warrant was pending. Then, what is the procedure that has to be looked into by the court? There are certain procedure laid down. Whether the procedure was followed by the learned court below. My humble submission is that no procedure was followed by learned trial.
That is on the merit.
Yes.
But like what
merit?
What I am basically
Because
concerned
it
is
will,
that
it will have, because
if a person is no longer a fugitive,
no,
then
my lord,
whether
what they will try to,
is,
their whole intention. I have seen ED cases, number of ED cases, their rate of conviction is only 4% to 5%. Their rate of conviction, that has been disclosed. In a Supreme, your lordship knows. Yes. Their whole intention is this. My lord, confiscate the property, put it in auction, sell it off. There is the basic idea is that. Because they know, most of the cases they are not able to connect it. Today, your lordship has seen that predicate offence, charge sheet has been filed, I am not been named. How you are dragging me into this case?
No. What I'm suggesting is that this has come to my mind.
Yes.
See, if the person is no longer a fugitive, then that order automatically goes.
No.
That order, because see, there is no necessity for order.
Your lordship, no.
No, that has to be set aside. I understand that.
Yes.
That has to be set aside.
Right,
Without setting aside, you can't do anything.
Yes, correct.
That order has to be set aside, but now since he is no longer a fugitive, an order saying, declaring him as fugitive, what is the validity
But
of that?
I don't want to leave anything, my lords, my argument in this case. These are all sensitive matter. I don't want to leave one single point also in this
No,
case.
that I understood. That.
Because these are very sensitive matter. We don't know in what manner it goes either of the party to the apex court. That's why I don't want to leave anything in this case. But that's why I want to argue further in this case. If they say tomorrow that this order 22/1/2025 will not
But
break any
they will not say so.
no, they will not say. That's why I want to argue addition. My lord, I will just quick. It's not very.
No, no,
my lord,
no. We'll
yes,
hear you.
my lord.
The only thing is
No,
that
I know, I
since
understand.
looking into the act,
Yes.
and like the object behind declaring somebody a fugitive, that has come to this
Yes.
court's
No,
mind.
no, that's true.
Since now he is there, already there, whether any order is required.
Yes. 12:9, my learned friend, I have not seen it.
So
12:9.
only thing is that like that confiscation part.
My lord, there has to be an order. See, 12:9. 12:9.
12/9
Of the Fugitive Economic Offender Act.
Yes, 12/9.
9. Page 7, my lord.
Yes.
Where on the conclusion of the proceeding, the special court finds that the individual is not a fugitive economic offender, special court shall order release of property or record attached or seized under this act to the person entitled to receive it. So it is not ED. This is what the judicial order has to be passed.
No, that is understood. I mean, this can be done. This can
No,
be done.
this-
This can be done only when it is
Yes.
set aside.
Yes, yes.
The court has to set aside it. Otherwise, not.
Yes.
Of course.
Yes. Now, my lord will kindly see. Now, your lordship will see now section 4. Kindly see section 4, my lord.
Section 4. Yes.
Section 4.
So 2F we have seen. Now,
You have
now
section 4.
Yes.
Before seeing section 4, my lord,
Yes.
your lordship will see at page 54. Keep one hand the Fugitive Offender Act. See my appeal, page 54.
54.
See. My application, my appeal, my lord.
Yes. Yes.
My appeal, and I have annexed at page 54. Page 54. The application which they have filed
Yes.
before the learned court of district and session judge. Lordship got it?
Got it.
Yes. Now your lordship looks into it. The name of individual Bhupeshwara, your lordship is seeing, cause title.
Yes.
Now see the next page.
The Gulsen Arora
List
is
of
there.
list of interested person.
Yeah, fee
Please note down because this has a connection with section 10.
Okay.
Please note down serial number 1.
Yes.
List of interest up to serial number 179. Page 65 up to page
Yes,
65.
all these people, correct.
My list of interested person. Please mark this, my lord. It is important. Your lordship can mark it. It has a connection with section 10.
Till 179, correct?
179.
Yes.
Page 65.
Yes.
Lordship got it?
Yes.
Now, please see page 65 now again. Page
Yes.
65. See the application which you have filed. Application file under section 4.
Application filed under section 4, read with section 10 and 12. Yes.
A fugitive economy amendment up to so and so. So these are the 4 they have filed.
Yes.
10 is the procedure that has been laid down. 12 is the order that has been passed.
Yes.
Right, my lord? Now, let's go to the statute. Now, let's go to the statute.
Yes.
See section 4, my lord.
Yes.
Declaration of fugitive economic offenders and confiscation of property. Section 4, 1.
Yes.
Where the director or any other officer not below the rank of deputy director authorized by the director for the purposes of this section has reason to believe, the reason for such belief to be recorded in writing on the basis of material in his possession, that an individual is a fugitive economic offender, he may file an application in such form and manner as may be prescribed in the special court, that such individual may be declared as fugitive economic offender. So this application has been filed. Section 4 read with section 10.
Correct.
Now my lord will kindly see section 10. Section 10. Now please see section 10. See section 10. Please see section 10.
Yes.
Application filed by them under section 4, my lord.
Yes.
Read it 10, 12. 10 is what, kindly see, 10.
Yes.
Where an application, 1, 10, 1.
Yes.
Where an application under section 4 has been duly filed, the special court shall issue notice, shall, my lord, kindly note down, shall issue a notice to an individual who is alleged to be a fugitive economic offender. So, my lord, here a notice to be issued, who has been declared as a alleged to be declared fugitive economic offender. Now, 10.2 is very important. The notice referred to in subsection 1 shall also be issued to any other person who has any interest in the property mentioned in the application under subsection 2 of section 4.
But this hasn't been done.
Nothing has been done. My lord, 1, when a notice has been issued to an individual alleged to be declared economic offender, 10.2 has to be followed. 10.2, that is why I have shown my list of interested property, my lord, list of those persons. So this 10.2, my lord, if you see the order, I'll read the order. This order said that no, now this will exempt it. 10.2 will be exempted. We'll go in respect to 10.1. Where is the power of the court to exempt it when it is making shall a mandatory, my lord? Kindly see the notice referred to in subsection 1 shall also be issued to any other person who has any interest in the property mentioned in the application under subsection 2 of section 4. Now, my lord, kindly see.
So they have prayed for some exemption?
No, nothing. Kindly see the order of this court. Directly I'll read what is 10.2 and how the court has dealt with. See at page 152, my lord. This become easier to connect. That's why I'm saying. 152, my lord. Kindly see, my lord, the second subparagraph. Impugn order, 152.
Yes, yes.
This is an impugn order, 152. How he dealt with 10.2. Kindly see 10.2. How he dealt with, this is an impugn order, 152.
Yes, 152 further.
Further, during the hearing of this instant application, applicant complainant has only pressed for declaration of the accused as fugitive offender. As such, notice as required under section 10.2 of FU Act at this stage, since not pressed by the complainant applicant, this court refrains from discussing on that aspect. Can they do it? It is a statute laid by virtue of an act. Can you say that no? Because now what? They are so eager to catch hold of this person, they can do anything what they want to do.
So that means like if somebody whose property is also being named, without hearing him, an order will be passed.
No, interested person.
Interested person.
Yes, named.
Whose property is also involved.
Yes, 179 name. So, the court said no, we will exempt. 10.2 later on we'll see. But that is not the intention of the legislature to legislate this law.
Correct. No, obviously, like, I mean, if somebody has...
And list of interested person, they have mentioned.
Yes, I mean,
Yes.
now it may happen
Yes.
that I have a joint property with him.
Yes.
I do not know anything about his,
Yes.
criminal activities.
Yes.
And I have been also named because I have a joint property with him.
Correct, right.
Now, without hearing me,
Correct, right.
so my property will be...
Property will go. My lord, that is what I am saying, my lord. Their whole intention is not criminal case. Their whole intention is confiscate. Declare him as economic offender, we will put it in auction. That's the whole case. That is their case, my lord.
Yes.
Now we go again back to the statute, my lord.
Yes.
Now see 10.3, what are the mandatory provision? Now see 10.3, what the court has to do it, my lord. 10.3, my lord. A notice under subsection 1 shall A. require the individual to appear at a specified place and time not less than 6 weeks from the date of issue of such notice.
So this hasn't been done.
No, not been done. There's a whole contents of the notice which mandatorily has to be followed. They have not done. They have not done anything. My lord, there has been some order complying all this provision, my lord. Now see
So
next.
This 3A or notice was also not sent.
No 6 weeks time. And B, state, now see, state that failure to appear on a specified place and time shall result in declaration of the individual as a fugitive economic offender and confiscation of property under this act. So this period
that notice was not given.
not given. Now you see, my lord, 4. A notice under subsection 1 shall be forwarded to such authority as the central government may notify for effecting service in a contracting state. So this contracting state, my lord, is a Dubai. So this through a central government, it should be sent. Now, my lord, then what happened? The authority referred to in subsection 5, in subsection 4, shall make efforts to serve the notice within a period of 2 weeks in such manner as may be prescribed. 6. A notice under subsection 1 may also be served individual alleged to have fugitive. So my lord, all this has not been complied by them. Now see the notice at page 39. See notice at page 39.
Page 39.
39. How they have done it? See page 39. They have taken so easily. Then day 1 they declare confiscate all the property. Confiscate. See page 39, page 20.
Accordingly,
was it?
accordingly issue notice.
Yes. See, accordingly notice. This is the notice, my lord. Issue notice to all the respondents. See now, my lord. Is this order, my lord, is sustainable? So that's why I said, I'll not take much time to connect this. Now, if you see this, my lord.
What is 11? 11 was
No,
12.
no, no. 12, kindly see. Power. To order.
So in 10, basically, they have violated this, correct?
Yes,
the
yes.
conditions, I mean, these terms of this 10 are not compliant.
Definition clause 2F and 10 has been violated.
Violated. And 12.
Procedure they have violated. So 12 is after hearing the application under section 4, if the special court is satisfied the individual is a fugitive offender, it may by or declare the individual as a fugitive or economic offender for reason to be recorded in writing. So this is 12, my lord.
So that this they have done.
This is an order they have passed. Now you violated all section 10 and you cannot pass an order under section 10.
No, I mean, this petition was heard, right?
It is petition heard.
And after finally disposed of.
After finally
And like
disposed
these issues were raised before him, the notice and all these things?
This notice was not, I think, is not really, because apparently it was not raised. But this being a law point, this being a draconian law, a High Court or any Supreme Court can hear this matter, my lord. These are law points, my lord, nothing to stay.
I just wanted to know.
Yes, it is territory violation, my lord.
No, but like
Because,
those points were
my
not
lord,
raised.
we were not in the trial court. That's why I will not be able to comment whether that argument.
But in the order?
Order.
Nothing has been discussed.
Nothing has been disclosed. See, my lord, apparently I have shown at page 152 how the learned trial court with great respect have dealt 10-2. We'll exempt 10-2 at this stage because that is what the complainant, the ED is saying. We'll take it on later stage. So this is one of the example.
And it was never taken.
Never
and
taken.
Final
order was passed. Because their whole motive is only to sell this property, to put on auction. Then what happens, my lord? Nothing remains in this case. Now, kindly see at 146, the judgment of this court, 146. At 142 it starts, the judgment. Yes. Your lordship was asking, but page 142 is a judgment.
Impugn order?
Yes, impugn order. Which is at page 143, my lord, is the impugn order 22/1/2025. 22/1/2000, which has been put to challenge by an appeal. 142 it starts, my lord. 142, kindly see, my lord.
Yes, I've seen this.
142, no? 140. What 142? Oh, starts at one. What was the paragraph? 146, my lord. Para 7. See para 7, my lord.
Yes.
See para 7. Further, in order to declare person as fugitive economic offender, section 2(1)(f) of FEO Act defines fugitive economic offender. Any individual against whom a warrant for arrest in relation to civil offence issued by any court in India who has left India so as to avoid criminal prosecution or being abroad. Now, in regard to requirement as specified in the above referred provision of FEO Act, trial against the present accused person is pending before this court for offences under section 3 of PMLA Act, read with section 4 of the PMLA Act, which is a civil offence under section 2(1) and M of FEO Act, L and M of FU Act 2008. Further, this court has issued open-ended non-bailable warrant of arrest by order dated 2/7/2024 against C. Bhupeshwara while disposing IA 230 of 2024. Yes, this is observation which is absolutely wrong, my lord, because Lordship has seen the order. 230 was recalled by this court. Thereafter, on 2/8/2024, the presence of the accuser exempted by order date 29/8/2024. Non-bailable warrant of arrest issued against the accused kept in abeyance, pending hearing application filed for cancellation of the said warrant of arrest, accused person. Thereafter, by order dated 5/9/2024, my learned predecessor, while disposing of the application IA 531 of 2024 for cancellation of non-bailable warrant, has kept in abeyance the non-bailable warrant till the next date and pass order for rehearing of IA 230 of 2024. This court, while order dated 18/10/2024, 13/12/2024, also granted extension of the order to keep the non-bail warrant in abeyance. In this regard, learned defense counsel has contended when no notice under FU Act was issued, when notice under FU was issued, no warrant of arrest was in existence. There was an argument. As the warrant of arrest issued against the accused was kept in abeyance. This was argued, my lord. No? Yes. Now, what the court says, it is a fact that when notice of FU was issued on 24/10/2024, non-bailable warrant issued against the accused was kept in abeyance. However, now kindly see, observe. However, it cannot be said NBW issued against the accused was not in existence, as no order of cancellation or recalling of non-bailable warrant was passed while disposing IA number 531 of 2024. As per section 72, every warrant of arrest shall remain in force until it is cancelled by the court which issued it or until it is executed. Therefore, in my considered opinion, merely because non-bailable warrant is ordered to be kept in abeyance from being executed, yet it remains valid, effective and operative unless cancelled. Hence, the requirement of FU is considered to be satisfied. Now, I am putting this way. I argued there is some observation made by this court while dealing prima facie. Now, there was cross-argument which has been made, counteracted by the other side. What do you mean by events? Now, suppose an order is being put to challenge of a learned trial court here, any case, and there is a stay order which has been passed.
No, then what will be the effect of the order of keeping in abeyance?
That is what we argue, and that is a judgment of our court. What is the effect of keeping in abeyance? That what the trial court said, maybe abeyance, but there is an order, some warrant of arrest is being kept. Until and unless it is not cancelled, you can't say. Abeyance is meaningless. Staying by any court becomes meaningless unless it has to be cancelled. When a matter is examined by the High Court, initially what the court does, we'll stay this operation of the order, we'll hear it. Affidavits are being filed, the matter is being heard, thereafter court takes a final call on that particular order. After hearing
it has to be re-effected.
Yes.
Re-effected.
Correct, my lord.
Otherwise, it becomes ineffective.
Yes, yes. This is what, my lord, we were aggrieved by the order, and we came up before this court challenging this order. And while deciding, prima facie, the objection also was filed by the other side, and an order was passed. Please look into that order, because that order will be relevant, my lord.
What was the objection they have stated? Relevant thing?
Now, my lord, I will just, before that, my lord, please take the act, my lord. Yes. Before the order, I showed the order of this court. One provision I'm sorry? I will show their objection. What is their objection? My lord, what their objection is that it is barred by section 14. Because we could not have filed this appeal. No appeal lies because it is barred by section 14. It is barred by section 14 of this act. That's why I want to show
what is in 14?
Yes, see 14. Please see 17 first, then I will show 14. See 17?
17.
1-7.
Yes.
Appeal. See, my lord?
Yes.
An appeal shall lie from any judgment or order, not being an interlocutory order of a special court to the High Court, both on facts or law. So, if it is a final order, not an interlocutory order, Whether it is, my lord, passed on facts and law, then only appeal lies.
Correct.
So here is a case, 22/1/2025 is a final order, whereby I am declaring the fugitive economy. So rightly we file an appeal in this court. Within 30 days, kindly so you see, my lord, every appeal under this section 17(2),
17(2), yes.
every appeal under this
30 days.
section shall preferred within a period of 30 days from date of judgment or order appeal for. So file on 22/2025. Your lordship, please note down. 22/1 is the impugned order. 22/1/2025. 22/1/2025, and we filed this appeal on 22/2025. 22/2025.
So 1 day delay?
Yes. Now, no delay.
2-day advance.
2-day advance, my lord.
28th day we filed.
28, 20, my lord. 22.
Or 20,
22,
20 you filed, okay.
20/2025.
Okay.
Now kindly see the proviso, my lord. Provided High Court may enter an appeal after the expiry of the said period 30 days, if it is satisfied that the appellant has sufficient cause for not preferring the appeal within period of 30 days. So there is, even after period 30 days, there is a provision for delaying also. Now see 14, my lord. Now see 14, where they are raising their defense and they are raising this objection.
Okay.
This is not maintainable. See 14. Notwithstanding anything contained in any other law for time being in force, A, on declaration of an individual as a fugitive economic offender, any court or tribunal in India, in any civil proceeding before it, may disallow such individual from putting forward or defending any civil claim, and any court or tribunal in India in any civil proceeding there before it may disallow any company or limited liability partnership from putting forward or defending any civil claim. If an individual filing the claim on behalf of company, limited liability partnership, any promoter or key managerial personnel or majority shareholder of company, or an individual having a controlling interest in limited partnership has been declared as a fugitive economic offender. Limited liability partners shall have the same meaning as assigned so and so. So, my lord, this is their defense.
On a declaration of with any court or in any civil proceeding, before it may disallow such individual from putting forward or defending civil claim.
They are saying that you cannot challenge any order passed by special court before any court. This is what their argument is. Any court you cannot challenge. Any order passed special court declaring me as a fugitive economic offender, you cannot challenge this order. That is their case. You cannot challenge this order. This is not maintainable. So
this section 14 only debars if there is a civil case pending.
Yes.
Wherein
some claims.
Wherein this fugitive is also a party.
Yeah.
Then on behalf of the fugitive, the other managerial persons of the company or the partner cannot appear. That is what I think it says.
Yes, correct. It only debars civil claim. There is nothing to do with declaring me as a fugitive economic offender.
No, but this section 17 gives you the power of...
Yes, that's what we are saying, my lord. That is why a prima facie court was satisfied and entertained this application. Now, my lord will kindly see. Last I will show the order. It will take 2 minutes, my lord.
Yeah, it's fine. No, you can. I mean,
what can I do it, my lord?
You can take your time.
No, what can I do it? Now 4:15. I can, in the 2:30, my learned friend will start. So if your lordship takes at 2 o'clock, then I'll read that order, my lord. I'll read that order, my lord. Then I don't have much of the judgment to say. Yes, Captain Evans, there is a judgment. What is the effect of Captain Evans? They have raised one point that who can swear on affidavit? Because affidavit has been sworn
by the wife.
By the wife. Whether she is entitled, whether she has right to swear an affidavit, we have shown a judgment. Damn it, dealt it. Yes. Your lordship will keep the judgment. Tomorrow we will show the judgment.
No, that our High Court also has a case. No?
Yes.
That it can be sworn by...
Someshwar Gogoi.
Someshwar Gogoi.
Yes. My lord will kindly mark the paragraph, then your lordship can go through it. It was 1984, 4 SCC, Lordship got it? 1984, 4 SCC.
1984, 4 SCC, yes.
Paragraph 14 and 15. This is keeping in abeyance. What is the effect of keeping in abeyance? Kept in abeyance, what is, do you mean, meaning it's? Paragraph 14 and 15. And another is,
Yes.
Delhi, no? AR 1976, Delhi 246. This is 1975 Supreme Court online, Delhi High Court, paragraph 14, my lord.
No, what is this? This is Hindu Marriage Act. Right?
Yes, yes, yes. Kept in abeyance. What do you mean by kept in? Kept in abeyance, my lord. Paragraph 14, my lord. Paragraph 14.
Yes.
यार पास नहीं हुई था आगे तक कोई गोली दिया जाती है होगा नहीं नहीं सोनेश्वर को गोली दिया मुंह नहीं दिया सर ना मुंह ऑर्डर टू कोर्ट there is one again judgment खाली दिखो नहीं no but देखा वो नहीं वो We'll show it tomorrow, my lord. One more judgment. So what I'll do in the morning at 2 o'clock, because as is starting 2:30, your lordship is taking other matters. 2 o'clock, I will show the order that has been passed in connection criminal appeal. What is the observation that has been made? Then I will show these 3 judgments. We'll do about 10-20 minutes. It will be over, my lord.
What about the other 2 matters?
Which 2 matters? Other?
That the item number of this thing?
1.
1 and
No, 1 I will take.
1 and 3.
I'll take instruction from my client whether to proceed or what to do, my lord. 1
and 3.
There is nothing to argue on 1, my lord.
And 3.
3, my lord. 3, my lord. We have to file, I think, additional affidavit in view. Why, my lord? In view of we are not named in the charge sheet. Now the scenario has changed, my lord.
So
it will have a ramification.
So all these matters have to be listed tomorrow, right?
Yes, yes. Maybe 1, maybe I don't know. I'll take instruction. Maybe I may withdraw this case. 1. 3, my lord, a complaint which we have filed for quashing of that complaint, which is pending PMLA case. Now the scenario has changed because they said that the public prosecutor has said that I have not named in the charge sheet itself. Now I have to bring notice to DICO. It has got a connection. Maybe not possible tomorrow. So only what is possible is 3. And my lord, which your lordship is hearing, 3 and
6 and 7.
Yes, 6 and 7.
6 and 7 and
Yes.
this thing.
Yes.
Item number 1 can be probably also like if you withdraw that.
Yes, withdraw, then end of the matter.
that end of the matter.
Yes.
Excuse me, calling for.
I have called.
And criminal petition 33, they have mentioned today, my learned friend mentioned. I think your lordship will look into it, my lord. Pleading is not completed. It is only an interim order has been passed. Your lordship will look into that and pass. Let it be listed so little matter can come up tomorrow also. Their pleading is not been completed, my lord.
So 1 will be listed tomorrow.
Yes.
Then
3 will be
3
listed.
will be listed tomorrow.
6 and 7
6
will.
and 7 part heard.
Yes.
Correct?
Right.
6 and 7 part heard. That's all. And like other matter has to be listed.
Yes, that is criminal petition 33 of 2025.
Item number 3, you write, let this matter be listed tomorrow. Item number 6 and 7, matter remained heard Mr. D. Das, learned senior counsel, assisted by S. Das, learned counsel. Hearing remained part heard. Let the matter be listed tomorrow, along with item number 7, that number you write. It has been mentioned before this court by the learned counsel appearing, learned PP, right?
Yes,
learned PP appearing for PP, it's called PPED.
Special PP.
Special PP for
Yes.
ED. That another matter, a number has been given it to you. No? Another matter so is also connected to item number 2 Connected to which matter?
No, there is, separately we have filed, no connection with those cases. Separately, criminal petition 33 of.
Then you write a similar case, submitted that a similar case pertaining to the same
Arising out of ML case number of 1 of.
arising out of
ML case number 1 of 2024.
is pending before this court, and the same may be also listed tomorrow.
Criminal petition number 33 of.
Number has been given, so they say let the matter be listed tomorrow with along with these matters.
And 1/3 of 2023, no, it is your complaint question, which is the number, complaint question? Item number 3, yes.
That is number
That is always there.
Yes.
That is always
Your Lordship, SG, Raju and SPB, Council Hassan may be reflected in the court order.
okay. You write Mr. R.
Mr. S.V. Raju and Mr. Zohaib Hussain.
Yes.
S.B. Rahu and Mr. Zohaib Hussain appeared for
ED, my lords.
for the ED through the video conferencing. You just type it out. I'll look into it. Okay. So tomorrow, Mr. Raju will argue, right?
My lords, at 2:30. My learned senior will be arguing from 2 o'clock. Then once he finishes, then Mr. Raju will take it over.
So all this matter will listed at 2 o'clock, my lord.
Yes, all these matters should be listed at 2 o'clock.
2 o'clock.
Obliged.
Deeply obliged, my lord.